Your Honor, I believe you're muted.
Yes, I'm sorry. Today is February the 20th, 2024. I am Judge Case Johnson. When I call your case, please make your announcements. Christopher Bartlett,
Your Honor, state is ready.
the
Your
state.
Honor, defense.
Wait a minute, who's the state? Where's the state? Raise your hand. There,
Your Honor, it's
okay.
me.
Yeah.
It's ASG Tipton. My apologies.
All righty, go ahead.
Your Honor,
Good
state is
morning.
ready on Mr. Bartlett's case.
What about Mr. Bartlett's case?
State is ready, Your Honor.
State's ready. Okay.
Morning, Your Honor. Defense is ready.
Okay. Dylan Billard,
Your Honor, I believe he's out to bond now.
okay, we will check on that. Kimberly, if you could please check the status of Mr. Billard. Jakayla Bryant,
State is ready, Your Honor.
all righty.
And defense is ready.
I'm sorry, Kimberly?
It's out to bond.
All right, great, thank you.
Okay.
So Jakayla Bryant, you said state is ready?
State is ready, Your Honor.
Okay, Mr. Lane, you're handling that
Yes,
one?
Your Honor. Yes, defense is ready.
Aaron Burgess,
Your Honor, he's currently out to bond.
he's out to bond, all righty. Ms. Kimberly, if you could verify that one. Xavier Choice,
Your Honor, I also have that Mr. Choice is out to bond.
okay. Kopich, Christopher Kopich,
Your Honor, I have that Mr. Kopich is out to bond.
okay. Ismael Dixon,
Your Honor, the state is ready on that case.
all righty,
Your Honor, defense is ready.
okay. Rodriguez Gates,
Your Honor, I have that Mr. Gates is out to bond.
okay. What about Jose Gonzalez?
Your Honor, state is ready.
Okay.
Defense is ready.
Isis Hines,
Your Honor, state is ready.
And defense is ready.
Brandon James,
Your Honor, I had that case was transferred.
transfer where? To Superior?
Yes, Your Honor. It says that it was, I just have transferred written on my notes here. I can check.
Okay, we will take a look at that one. Kimberly, if you could find me the warrant on Mr. Brandon James, please. Eric Jones,
Your Honor, state is ready.
And defense is ready.
Jaleel Jones,
State is ready, Your Honor.
And defense is ready.
Hayden Lowry,
State is ready, Your Honor.
Attorney Lane,
Defense is ready.
Javon Martin,
Your Honor, I have that case is closed. I looked it up earlier. It looks like it's already been disposed of in Judge Jones Parker's courtroom.
and so Ms. Kimberly, if you could please check on that, make sure. Devon Matthews,
State is ready, Your Honor.
Defense is ready.
Heather Miracle,
Your Honor, state is ready. The state would ask that this case be heard second. The officer who is excuse me, the officer who's on this case is currently on annual leave and is zooming in from a cruise ship on his vacation.
Oh, wow. And this person is only charged with criminal trespass?
Yes, sir.
Okay,
Good morning, Your Honor. Justin Moore on behalf of defense, second half of the alphabet. And we're,
okay, so Mr. Moore, you're for Miracle?
yes, ma'am, for
Okay.
Lister Dennis on all, M through Z.
What? Okay, maybe. Oh, there you are. All right, Mr. Moore, got you.
Yes, ma'am.
All righty. And what about Corey Morgan?
State is ready, Your Honor.
Your Honor, if we could reserve him to a point where I might be able to just have a brief word with him. We may not need to have a hearing.
All righty. All right, Corey, okay, Corey Morgan, hold. Corey Myers,
State is ready, Your Honor.
Defense ready, Your Honor.
Randy Phillips,
State is ready, Your Honor. We would ask this case be third. This is the same officer that I discussed earlier.
is
Uh,
this an airport case?
I don't believe so, Your Honor. Let me double check.
Okay, but let's keep going out. We can check after the calendar.
Your Honor,
Tamir, uh-huh,
I think they're both airport cases for that officer, is my understanding.
all right, Tamir Robinson,
Your Honor, I have that she's out to bond.
okay. Michael Solo,
Your Honor, state would request a reset. The officer is on annual leave until the 21st of this month.
Your Honor,
I'm here.
Oh, you're here, Officer Descorbeth?
Yes.
Okay.
Oh. great, thank you.
Okay. Thank you for coming in on your off day, sir.
Right, thank you. And I would like to hear this case fourth,
Yes,
Since-
Your Honor.
since he's off today. Edwin Spears,
Your Honor, I have that he is out to bond.
okay. Demario Stevens,
Your Honor, Officer McFadden has been in contact with our office, but for whatever reason is not on the call. We would ask that Your Honor holds for our investigator to make contact with him.
okay, and so, and Mr. Moore, this is your case, right?
yes, Your Honor, and we're ready.
Okay, all righty. And Derek Thrash,
Your Honor, Mr. Thrash, as well as Mr. Hines from earlier in the calendar, I missed telling Your Honor, but the state believes it would be more appropriate to have this heard on a felony preliminary hearing. This is alleged to have occurred in the Clayton County Jail, which would have been in violation of 16-10-56. Which specifically states that violence in a penal institution is a felony.
okay, I'll take a look at that one.
Your Honor, for defense part, I guess a couple issues. First, we would be ready to proceed pending a quick discussion with Mr. Thrash. Additionally, we didn't receive, I can't speak as to Mr. Hines, but with regard to Mr. Thrash, we're kind of in the dark as far as what occurred, in that the police report doesn't reference anything that occurred with Mr. Thrash. And so I can't really speak to whether or not defense agrees with the state until we get a little more information about what's alleged to have occurred here.
Okay, all righty.
And Your Honor, if I could, Mr. Matthews, who's also on the calendar, he's involved in the same incident. And again, we have the same problem. It's that same incident report that doesn't really have any detailed facts on what, if any, involvement Mr. Matthews had along with Mr. Thrash in this.
Do you happen to have that warrant handy?
Yes, Your Honor, and I have the police report. I have an updated police report that was submitted by Deputy Rivera. I can,
Okay.
I can
Email
forward
that to, yes, please send that to me. Thank you.
Yes, Your Honor.
Shaki Tripp,
Your Honor, we are currently waiting on Officer, let me see if the officer has.
Officer King, I'm available.
Officer King, thank you, Officer King. It is ready.
Fence is ready, Your Honor.
All right. Denise Washington,
Your Honor, state would request a one-time continuance. The officer is in training today.
And Your Honor, for defense part, we would object to any continuance. My understanding is that Ms. Washington has been in custody for over a month at this point, has not yet been heard on the preliminary hearing. Given the nature of the charges, the fact that they're misdemeanors, we would ask that it be dismissed for warrant of prosecution.
and so, Assistant Solicitor Tipton, can you tell, or can anybody tell me the exact date that this person went, that Ms. Washington went into custody?
Yes, Your Honor. If I may have one moment, I'll pull that right up.
I have it as the incident occurring allegedly on January 17th, taken into custody per the report.
And Your Honor, I have that as well.
Okay, all righty.
I also, my apologies, Your Honor. I was just, did mean to interrupt the court.
No worries. Okay, all righty. So, and then last but not least, Bobby Willingham.
It is ready, Your Honor.
Fence is ready, Your Honor.
Okay, so you guys can start. I want to start looking at some of these warrants. I would like to start a hearing in 5 minutes. And so you can let the jail know exactly who they need to have first. And we can go ahead and begin.
Yes, Your Honor. And just, Your Honor, I forgot to mention this. Officer Mesa Dew on the Corey Morgan case, he worked overnight, so we would ask that that case be first.
So Morgan.
Yes, Corey Morgan. Yes, Your Honor.
All right, we will hear that case first. And just to verify, 1, 2. Okay, so there is a Corey Morgan, and then there is a Corey Takevius. Well, that's Myers. Okay, I'm sorry. So Morgan has 2 cases, right?
Yes, Your Honor.
All righty, hold tight. We'll get started.
And Your Honor, while we're waiting in this time period, would this be a time where we could briefly jump in to check those conflicts on those 2 and possibly have a quick discussion with Morgan, or did you want me to wait until a different time this morning?
Wait, say that one more time. You were talking a little fast.
Sorry, Your Honor. I was just asking if while we're during this 5-minute period, would it be all right? Did you want us to go ahead and jump in with the jail and we had a couple of quick discussions prior to beginning a couple of hearings, or did you want us to wait until those hearings?
No, go ahead. If you can be back in 5 minutes.
Yes, ma'am. And Mr. Tipton, would it be okay for us to receive that information for the 2 jail cases, the Thrash and the I believe it was Matthews? Is that right, Mark?
Yes, that's the one where we have a potential conflict and we're missing a detailed report.
Your Honor,
So
I'll be happy to do that too. Oh, I'm sorry.
Okay, Clayton, the jail, I just put in 1. And who else do I need to put in 1? Mr. Moore?
Yes, please, Your Honor. And Mr.
Anybody else? Mr. Lane, you want to go in as well?
Yes, Your Honor. Thank you.
All righty.
And I will send that detailed report to both defense attorneys, and I believe Your Honor also wanted a copy of it.
And before you guys go to the breakout room, Deputy, can I get the jail to turn on their camera? Hello? Wait a minute, where is the jail?
I saw him a minute ago, Judge.
Oh, they've already, hold on. They've already,
Oh.
I think they're in a break.
Judge, did you want us to go ahead and join with the jail? Or
I'm sorry about that. Devon Martin says that the case is closed. You don't have him, right, Deputy?
Did you say Martin?
Yes, Javon Martin.
I don't.
Okay, just wanted to make sure. And you don't have a Tamir Robinson, correct?
That's a negative. I don't have Robinson either.
Okay, and neither do you have Edwin Spears.
No.
Okay, okay, all right, yes, go ahead and join.
Okay.
thank you, Your Honor.
All right. All right, so who did we say we were starting with first?
Your Honor, that was going to be Corey Morgan, who is,
Morgan,
yes, Your Honor, that the officer worked overnight.
okay. And do we have him, do we have the inmate yet?
Your Honor, thank you for the time in the other room. I think we can kind of update the court a little bit if you're ready.
Okay, hold on 1 second. Mhm. Okay, go ahead.
Thank you, Judge. With regard to Mr. Morgan, with his express, Corey Morgan, with his express permission, whenever the hearing is finished, if it's all right, I'm going to provide a waiver of both of those warrants to the court to waive his preliminary hearing.
But you're saying after the hearing?
Or whenever. I'm making that, I'll put that on the record right now, but as far as writing up the waiver, I was going to present that to you whenever we were finished.
Okay, so if we do a waiver, then we don't have to have we don't need, there's no need for a hearing.
That's my intent, Your Honor. Yes.
Oh. All right, so I'll just put this as a waiver, and then I would just expect to get that from you guys.
Yes, ma'am. A few
Okay.
minutes after we finish today, I'll send that over to you.
Okay, great. All right, then who would be next?
And we also spoke with the two gentlemen in the jail incident, Mr. Devin Matthews and Mr. Thrash. And in our discussion, we do not have an issue for the conflict, so we're ready to proceed and discuss however we need to.
Okay, so that was on Matthews. So that's just ready, right?
I think pending our discussion about whether or not it's a felony or what, whatever's going on with the state on that.
Yes, Your Honor.
For position 26, Devon Matthews? Are we talking about Devon Matthews?
Yes, Your Honor.
And so that simple battery he's saying should be upgraded to a felony?
Yes, Your Honor. So, anytime there is a violent crime to have alleged to have occurred inside the penal institution, it would fall under 16-10-56, which states that, let's see, no person legally confined in a penal institution shall commit an unlawful act of violence or any act in a violent or tumultuous manner in a penal institution. Any person who violates this code section shall be guilty of a felony. Upon conviction thereof, shall be punished by imprisonment of not less than 1 nor more than 20 years. So if there is probable cause, it would automatically be a felony.
Okay, so, okay, because I see what you're saying. That was the other one too, Mr. Thrash.
Yes, Your Honor. It was Mr.
Okay.
Thrash, Mr. Isis, and Mr. Matthews.
Oh, so it's 3 of them.
Yes, Your Honor.
I see, okay. I will take a look at that too. All right, so the person on the officer on Morgan Court, you're free to go. But they already dismissed?
No, Your Honor, but and let me correct that, Your Honor. I do apologize. It did not include Mr. Isis. I just misspoke earlier. I wrote down the wrong name.
Okay.
And but Your Honor,
But it's the Morgan and the Thrash.
yes, Your Honor, it's Matthews and Thrash. Matthews and Thrash. Morgan was the one that the defense is waiving.
Okay, Matthews and Thrash. All right. And so has the officer been released on Corey Morgan?
I have not released him, Your Honor. He may have logged off. Officer Methodiu, are you there, Officer Methodiu?
Yes, I'm here.
You're
All right.
excused.
Your excuse. Thank you, officer.
Thank you.
All righty. And is there anyone here, any officer here for Dylan Bellard? Speak now, forever hold your peace. What about Baron Burgess? Xavier Choice? Christopher Coppage? Rodriguez Gates? Javon Martin? Tamia Robinson? Edwin Spears? All right, so I just wanted to make sure those officers were released. All righty, and so who are we doing next? Attorney Tipton?
Your Honor, the state would request that we do Heather Miracle or Heather McCallie. Next, Officer Parker is on, and he is currently phoning in from his vacation.
Okay, so Heather Miracle. All right, Deputy, if you could get Heather Miracle, please. Hold on, Miss Miracle. We're about to start your hearing. Hold on. All righty. Now calling the matter of State of Georgia versus Miracle Heather, warrant number 2024 WA 01477. Where did everybody go? There we are. Criminal trespass representing the state is Assistant Solicitor Tipton. Representing the defendant is Attorney Moore. Your witness, Attorney Tipton.
Yes, Your Honor. The state is going to call Officer N. Parker to the Zoom call. Officer Parker, please raise your right hand. Do you swear or affirm any testimony you should give today shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Please lower your hand. Okay, officer, please state your name for the court.
Officer Nathaniel Parker.
Okay, Officer Parker, are you currently employed as a law enforcement officer?
Yes, sir.
Where are you employed at?
Atlanta Police Department.
And do you work out of the Atlanta airport?
Yes, sir.
I see. Okay. Are you currently post certified?
Yes, sir.
Being post certified, are you certified to make arrests and investigate crimes?
Absolutely.
Yes, sir. Were you working on the day of January 18th of 2024?
Yes, sir.
Did you have occasion to make contact with Miss Heather Miracle on airport grounds on that day?
Yes, sir.
Okay. Can you tell me a little bit about that interaction?
Okay. On that particular day, I came in contact with Miss Miracle. I knew that she had a trespassing warning based on, it was like a couple of days prior, or maybe it was the day before, that she had stole some items from one of the establishments in there, and at that point they just wanted her criminal trespass from the property. Just so happened she came back the very next day. I mean,
so I want to make sure you were aware of a criminal trespass warning that was issued to Miss Miracle.
yes, sir. I believe I gave it to her.
Okay. And she was specifically told not to come to that portion of the air. She was specifically told not to come to the airport. Is that correct?
She was told not to come back unless she had a flight or some kind of airport business.
Did she, when you approached her, did she say that she had any airport business?
No.
Okay. I see. Based on your knowledge, training, and experience, would that be tantamount to a criminal trespass?
That would be.
All right. Thank you, sir.
Um,
No,
right,
no
Ross?
further questions.
Ross?
Thank you, Your Honor. Good morning, officer.
Good morning.
I'll be brief. I apologize that you're on your vacation here, so I'll move it along. So the previous trespass warning, you said you believe you gave it to her, correct?
I'm not looking at, I don't have the paperwork in front of me, but I'm generally in that area. So it's either me or two other officers that possibly gave it to her. But I remember dealing with her that day. She had on a flowery dress and a sweater, I believe.
So it's possible that you gave her the trespass.
Yeah, almost 100%.
Almost 100% possible.
Yes.
When you give out trespass warnings, are they generally written or do you just give a verbal warning? How does that usually work?
It's a form that's filled out and placed in our files. When we give them a trespass, we generally give them a MARTA card so they could exit the property. The reason she came back, I don't know.
On the day in question, the day that we're talking about, not a previous encounter, but on the day in question, when you encountered her, you did not ask her if she had any airport business, correct?
Oh, I do.
I'm sorry.
I do. I generally ask that. I mean, why are they here?
Gotcha. Do you recall any answer?
I believe she said she came to get something to eat or something like that. I'm not sure. I'm not. It's been 2 months or a
Is
month.
that? I'm sorry. I didn't mean to interrupt you. Go ahead. I was just going to say, is eating or any business in the atrium, would that be considered airport business?
Not necessarily. Not necessarily. You could consider that, but it's not a flight.
Gotcha. So, okay. How are you authorized to trespass people from the airport?
I work at the airport, and we're given that authority to.
Who gives that authority to you?
You'd have to talk to the heads, the main heads that actually run the airport, DOA, everybody on the 4th floor of the atrium.
All right. Thank you, officer. No further questions.
Any redirect?
Very briefly, Your Honor. Officer Parker, as part of you mentioned that there's a system for criminal trespasses, for logging criminal trespasses. Is that correct?
Yes, sir.
Did you check to see if Miss Miracle had a criminal trespass warning logged into the system?
Yes, it's legit. Files. You know, we take. Well, I know what I do is I take a picture along with the criminal trespass and I file it.
And I just want to confirm, you confirmed that you gave her a criminal trespass sometime immediately prior to this, correct?
Yeah, I'm looking at the report right now, and I gave her a criminal trespass on the 17th of January, and she came back on the 18th of January.
Okay, thank you. No further questions.
All right, based upon the evidence presented, I do find that there is sufficient probable cause to bind this case over to the state court of Clayton County. That's the order of the court. All right, who do we have? Who you want to go with next?
Your Honor, next I'd like to have Officer Parker's other case, Randy Phillips.
You want to have who? Who did you say?
Randy Phillips, Your Honor.
Randy Phillips. All right. If we can get Randy Phillips.
And Your Honor, in the interest of judicial economy, would the court like me to, will the court take notice of Officer Parker's credentials from the previous hearing?
No, let's just go ahead and do it. Just go ahead and do it.
Yes, Your Honor.
All right, we're about to start your hearing, Mr. Phillips. All right, Mr. Phillips. Now calling the matter of State of Georgia versus Randy Phillips, charging warrant number 2024 WA 01478, charged with criminal trespass. Representing the state is Assistant Solicitor Tipton. Representing the defendant is Attorney Moore. Your witness, Attorney Tipton.
Yes, Your Honor. State's going to call to the Zoom call Officer Parker. Officer Parker, please raise your right hand. Do you swear or affirm any testimony you give today shall be the truth, the whole truth, nothing but the truth, so help you?
Yes, sir.
Thank you. Please state your name for the court.
Officer Nathaniel Parker,
Officer Parker, how are you currently employed?
Atlanta Police Department.
Are you post-certified?
Yes, sir.
Being post-certified, are you authorized to make arrests and investigate crimes?
Yes, sir.
Are you employed with the, are you stationed at the airport police department precinct?
Yes, sir.
Okay. Were you working on the date of January 18th, 2024?
Yes, sir.
Did you have occasion to make contact with the defendant on the Zoom call, Mr. Randy Phillips?
Yes, sir.
Do you see Mr. Phillips on the Zoom call?
I do.
Can you identify him based on something he's wearing?
Black male, red jumpsuit.
Thank you. Could you tell me about what occurred that day, please, officer?
He's one of the regulars. Basically, I came in contact with him. Same as always in the atrium. Immediately recognized he had just been issued a criminal trespass 20 days or about 20 days prior.
I see. And did you confirm that in your system that he had that criminal trespass warning issued to him 20 days prior?
Yes.
Okay. And at that point, did you make an arrest based on criminal trespass?
Yes, sir.
Based on your knowledge, training, and experience, was that a criminal trespass?
Yes, sir.
Okay. Thank you, officer. I have no further questions.
All right, Cross.
Thank you, Your Honor. Officer, I know you said that he was one of the regulars. Did you recognize him? Sorry, did you hear me
Excuse me.
okay?
No, I didn't hear you.
Sorry, here, I'll get better. You said that he was one of the regulars. Is that because you recognized him?
Him like, I mean, I take pictures of him, so I mean, I generally recognize the faces that I come in contact with regularly. So he is one of the regulars.
So you didn't recognize him?
I can't say for sure if I recognized him. I believe I came in contact with him because he was sleeping.
Okay. The criminal trespass warnings, did you provide the previous warning in this case?
I can't believe, like I said, I'm not looking at the file.
So you're not sure if you provided the warning?
No,
Okay. Um, Now, did you discuss his business with him at any point in your contact?
I always discuss what's their purpose on the property.
Do you recall having that discussion with Mr. Phillips?
I can't say for sure. I mean, there's a body camera, so you can view that.
Gotcha. And again, for the record, your authority to trespass, you're not sure exactly where that comes from?
The airport, that particular part is the airport is actually owned by the city of Atlanta, so we're given arrest powers to issue criminal trespass in that manner, especially if they're actually breaking the law.
That's not relevant. We're moving on from that, please.
And I don't have any further questions, John.
All righty. And so any redirect?
Just one question, Your Honor. Officer Parker, did you check your files to see if Mr. Phillips had an active criminal trespass warning?
Yes, sir.
And did he have one?
Yes, sir. It was issued on December 28th.
Thank you. No further questions.
Alrighty. So based upon the evidence presented, I do find that there is sufficient probable cause to bind this case over to the state court of Clayton County. That's the order of the court. Thank you, officer.
Your Honor,
Thank you.
for future reference, usually customary for me to at least make some sort of argument regarding the facts. I would prefer to do that at least briefly in the future if possible.
Well, rather he has authority to arrest him? Was that your question?
No, I'm not referencing the question, Your Honor, as far as argument with regard to what the officer was discussing and whether or not there's probable cause.
So you're saying you want an opportunity to have a closing argument. Is that what you're saying?
Yes, ma'am.
Okay. So be it. Okay, who are we doing next?
Your Honor, next would be Solo. Officer Discorbeth is in on, Your Honor, may we excuse Officer Parker?
Yes, thank you, Officer Parker. Have a good one.
All right.
Enjoy your vacation, officer. Thank you so much for coming
Appreciate
in.
it. No problem.
Hold on one second while let the deputy know who they need to get next, please.
Michael Solo.
All righty, now calling the matter of State of Georgia versus Michael Solo. Charged in warrant number 2024 WA 70653, forgery in the fourth degree. Representing the state is Attorney Assistant Solicitor Tipton. Representing the defendant is Attorney Moore. Assistant Solicitor Tipton, your witness.
Thank you, Your Honor. The state calls to the Zoom call Officer R. Discoberth. Officer, please raise your right hand. Do you swear or affirm any testimony you give today shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Please lower your hand. Please state your name for the court.
Officer Regis Discoberth.
Thank you, Officer Discoberth. Officer Discoberth, how are you currently employed?
I'm currently employed with the Clinton County Police Department.
Are you post-certified?
Yes.
Being post-certified, are you authorized to investigate crimes and make arrests?
Yes.
Thank you, Officer. Officer Discoberth, were you on duty on January 18th of 2024?
Yes.
Okay. Did you have occasion to go to the Chase Bank on Highway 138 Southeast?
Yes.
Why did you go there, sir?
We had a call about somebody bring a check that was fake to the bank, and I went there meet with the manager, and the defendant left his ID at the bank, so they give me the check and they give me his ID, and I send the picture of his ID to my lieutenant because they believe he was still in the plaza, and my lieutenant located him inside the Kroger. And I went to meet with him and talk to him about the check. He said that he received the check because he does handiwork, but he would not provide the person that gave him the check information. He said that he would give those information to the district attorney when he get a chance to speak to the district attorney.
Okay. So I just want to make sure I understand. So when you arrived, did you make contact with the bank manager?
Yes.
And what did the bank manager tell you regarding the defendant's behavior at the time?
He did not. He wanted his money, and he did not want to stay. When they asked him to be patient, they gonna give him the money. He just walked out. He left his ID with them and walked out.
And I just want to understand, and I just want to make sure I understand. Did you have his ID at that point once you arrived?
Yeah, once I arrived, they gave me his ID, and I sent a picture of his ID to my lieutenant that was looking for him since they say he was still in the plaza, and my lieutenant located him at the Kroger.
Did the bank manager make contact with the person who with the account which the money was going to be drawn from? With the
Yes.
person with that account?
Yeah, they make contact with the account holder, and they said that they did not write any check, they did not authorize any check, and the bank manager also told me he was the second person that came in the bank with a check from that same account on that day, which is why the account was already flat when he came.
I gotcha. And you mentioned that the defendant stated he received the check from a job that earlier that week. Was he able to identify the person who gave him that check?
No, he was not able to provide me the name, the phone number, how he come in contact with him, but he said he had all the information on his phone, and when he would get a chance, he would give all this information to the district attorney.
I see. Did all this occur in Clayton County?
Yes.
Okay.
All righty. Cross.
Thank you, Your Honor. Officer, who was the person, what's the name of the person in the check whose name it was in? Can you tell us that?
I don't have my report in front of me. Let me see if I could put it. I don't remember the name right now.
It's, I believe it's to David Wilbur Jr.
I see. Did you see the check?
Yes,
Did you see to whom the check was made out?
yes.
Who was the check made out? To whom was the check made out? Sorry.
Michael Solo.
Okay, and could you tell the handwriting on the check? Was there any comparison done on that?
No, there was no.
Was it alleged that this is a stolen check or that this is something that he made up? Do you know?
It's just something that was made up.
As in, it was not a legitimate check, but rather it was created by printing or something to that effect. Is that?
Yeah, they say it was made up. But he had all the account information on the check.
I see. You didn't personally speak to the victim, is that right?
No, the man just spoke to the victim.
And so, in speaking with Mr. Solo, he indicated he received the check from a third party. Is that right?
Yes.
See, and you weren't able to follow up on that to see if there was a third party that had passed that check to him. Yes?
No, he refused to give those information.
I see. No further questions, Your Honor. Thank you.
Any redirect,
None from the state, Your Honor.
closing arguments? Attorney Tipton?
Yes, Your Honor. Your Honor, this is the classic situation of forgery. Per the OCGA, the only thing the state needs to prove to show forgery in the fourth degree is that someone makes, alters, possesses, utters, or delivers a check in the amount of less than $1,500 in a fictitious name or in such a manner that the check is as made or altered purports to have been made by another person at another time with different provisions or by authority of one who did not give such authority. And that's what we have here, Your Honor. We have a check here that was made without the authority of the victim. I suspect the defense will argue that the check that the officer did not speak directly to Mr. Wilbur. However, in these sorts of hearings, hearsay is allowed. Hearsay is, and the officer in his investigation did do his due diligence in speaking with the bank manager. Banks have their own internal investigations, and those internal investigations can be given to police officers. If this case were to go to trial, we would call the bank manager. But for the purposes of this hearing, the information given to the officer should suffice. Further, Your Honor, the fact that the defendant was not able to give any information of the person who he allegedly did the job for and paid him with this check is suspicious in and of itself, and that would give the officer further suspicion to make the arrest. The amount of the check was $1,060, so it's still within the bounds of fourth degree forgery. It occurred in Clayton County, and the bank was tipped off by suspicious activity, not just from this defendant, but also a prior check that was suspicious from this account. The officer explained that the defendant was acting suspiciously in the bank, and the officer was also given the defendant's identification card. And the defendant confirmed his own identity when he said that yes, that was his check. For that reason, Your Honor, the state believes that there is probable cause for this forgery.
All right, thank you. Go ahead, counsel.
Thank you, Your Honor. First and foremost, I don't recall the officer actually identifying my client as the person involved in this situation. Aside from that, Your Honor, the facts regarding the check are very sparse. I know the officer gave at least some tacit indication that perhaps it was a fraudulent check, as in it had been created fictitiously. However, we haven't seen the check. We have no image of what's on the check. We don't know who signed it. Presumably, we know who the account that is drawn on. However, that was obtained from the bank manager who supposedly spoke with the alleged victim, Mr. Wilbur, I think it was. We have hearsay within hearsay. I understand hearsay is permissible here, but the reliability of that third degree hearsay is suspect, to say the least. So without producing the check, without producing some more detailed facts, we have a very nebulous idea of what occurred here. We don't know where this check came from, the details, what supposedly he did to have forged this check, whether he made it himself or whether he stole it, or how this is supposed to have come about. And then finally, the fact that we're not sure if this is the gentleman who was in fact in the bank that day. So for those reasons, I would argue there's not probable cause here for this charge. Thank you.
Thank you. So based upon the evidence presented, I do find that there is sufficient probable cause to bind this case over to the State Court of Clayton County. That's the order of the court.
Thank you, Your Honor.
All righty, who are we doing next?
And Your Honor, may I excuse Officer Discorbus?
Thank you, yes.
Thank you, Officer Discorbus, and enjoy the rest of your day, officer. Thank you.
All right, thank you.
Your Honor, I believe that those were all of the cases where we had folks that were that needed to go out of order. May I sound once more to see if there are any officers who worked overnight?
Yes, please.
Yes. If there are any officers who worked overnight, please let me know and I will call your case and we can call your case next.
Yes, sir. This is Sergeant Malalte with the Clayton County Police. I normally work night shift. It's actually my off day today, so I work overnight and it's supposed to be off.
Okay. Your Honor, may we take Officer Malaute? Also, Your Honor, did Your Honor, I know that we spoke briefly about the Matthews and Thrash matter. I've still got my officer on for that. Did Your Honor intend to reset that for a felony?
Just give me a few more minutes. I need to pull their warrants and look at them very briefly.
Oh, yes, Your Honor. I'm sorry. Your Honor want me to forward the
Please. Is
yes,
that the one you were gonna, it was another one you were gonna forward me the warrant?
yes, Your Honor. I've got the police report handy. I can go get the warrants immediately after, but let me go ahead and forward, Your Honor, the warrants. I mean, the police report.
And for Brandon James, it was one that Attorney Moore, it was a concern. He said he didn't have a copy of the report to determine which case was that?
I'm sorry, Your Honor. What I was discussing was the situation with Thrash and Matthews and Hines.
That's okay.
Yes, ma'am. It's all wrapped up.
Okay. All righty. All right. Yeah, if you can send that over to me, and that officer is on what case?
The other officer Malaute, I believe, is on the Gonzalez matter. Let me just double check that. Yes, he is. He's on the Gonzalez matter.
Gonzalez?
Yes, Your Honor.
You sound really muffled. I'm not sure why.
Let me see.
No, it's just that fast. It got better.
Okay, it got better. Let me swap out my chair and get a little closer to my computer.
Okay.
Do I sound less muffled, Your Honor?
You sound better.
Thank you, Your Honor. Gonzalez.
And so, Deputy, if you could please get Mr. Jose Gonzalez. All right, now calling the matter of State of Georgia versus Jose Gonzalez, charged in warrant number 2023 WA 73193, representing the state. Again, is Attorney Solicitor Tipton, representing the defendants is Attorney Mark Lane. You're
I'm
witness.
sorry, Your Honor, real quick. I just realized Mr. Gonzalez, it looks like there's the attorney is Douglas Smith on here on the calendar. I don't see where our office was appointed. I'm not finding him in file line.
All righty,
I do have Mr. Smith's phone number, at least here on the calendar. I don't know. I'm gonna try to.
and so, Ms. Thomas, if you could reach out to Douglas Smith, to make sure that he is in, see if we got an entry of appearance from Mr. Gonzalez.
Yes, Your Honor, I'm checking now.
And if you would ask the inmate if he know anything about a private attorney being retained. Mr. Lane?
Oh, I'm sorry, Your Honor.
That's okay.
Yeah, and I apologize. I should have caught this earlier, but yeah, just looking at this, and I was wondering why I was missing the incident report. This probably explains it. Is that why it wasn't sent over to our office? But if we do need to go forward, if Mr. Smith,
No, I'm saying if you could ask Mr. Gonzalez if he knows that or knows that a private attorney has been retained in his case or not, or
okay, Mr. Gonzalez.
Yes, sir.
My name's Mark Lane. I'm a public defender. I was looking here. Do you know a Douglas Smith? Have you spoke with him as your attorney?
No, it was Eileen Dalton.
Elaine Dalgo?
Dalton.
Okay. That's your attorney?
Yes, but she said that maybe she's not going to be my attorney in the case later on. I'm trying to do my best.
Okay.
so the question is, did his family actually retain an attorney in this case? He says
No.
I don't know.
Oh, you don't know? Yeah.
Okay, let's
Your
go.
Honor, it looks like that number that I called is the public defender's office. I was just placed on hold.
Oh, Doug Smith. That's the Douglas Smith. That is the attorney. That's the public defender for felonies.
See what I got.
Attorney. I'm not sure how that got on here.
Okay.
Put that email to Williams.
Douglas Smith is the attorney for felonies.
I didn't realize that.
Yes, I'm not sure how that got on there. All right, so can we proceed, Attorney Lane?
Your Honor, if I could, I don't have the incident report. If Mr. Tipton could send that over to me and maybe give me a minute to get up to speed on it. Maybe if we could go to another case.
Okay. I'm sorry, Deputy. We're gonna come right back. Officer, we're gonna come right back to you, I promise.
Yes,
ma'am.
While he's reviewing that. All right, and so what would be the next one, Mr. Tipton?
And you may, I guess I've got all the next ones. So I guess if we're trying to give me some time to review it, I don't know if we want to go to the back end of the calendar, starting with Myers to the end. That way Mr. Moore could be doing maybe the hearing while I'm studying up on Mr. Gonzalez's case.
That would be great. All right. And so are we ready on Corey Myers?
If I may have one moment, Your Honor, I believe so. Yes, Your Honor, we are. I just need to send Mr. Lane
That's
there.
fine. I need to step away for 30 seconds.
Yes, Your Honor, I will be right back as well.
Okay. Okay, so, Matthews and Thrash, after reviewing the statute, Matthew and Thrash is in fact a felony, and that will be removed and placed on the felony calendar.
And Your Honor, I had some trouble getting you Hines' report, but Hines also occurred in the.
Wait, say that one more time.
My apologies, Your Honor. I was having some technical difficulties, but Miss Hines also, her crime was alleged to occur in the jail. It was a different incident, but it did occur in the jail. I was about to send you the warrant for Hines. I just got through some technical difficulties.
But it happened in the jail?
Yes, Your Honor, it occurred. It occurred.
Right. We will, Matthews, Thrash, and Isis will be placed on the felony calendar.
Thank you, Your Honor. May I excuse Deputy Rivera and Deputy Harris?
Yes, thank you.
Thank you.
And Judge, do we have that felony preliminary hearing date?
Yate, what day are you gonna put them on?
March 6th.
Okay, thank you.
Okay, so we're gonna do March 6th.
Hey, Attorney Tips.
Yes,
I'm sorry?
Oh, sorry. Yes, Deputy Davis, you're excused.
Yes, sir. Thank you.
Thank you, sir.
Yes, sir.
Okay. Okay.
Excuse me, Your Honor, Deputy Rivera, may I be excused from the court?
Your Honor, that was the deputy that I'm not sure if Mr. Rivera heard me, but if Deputy Rivera heard me, but I did excuse him. He was on the Thrash and Matthews matter.
Okay, yes, you are free to go.
Thank you, Your Honor.
Thank you. All right, and
Thank
so
you,
who
Deputy Rivera.
who can we do next? Who are we ready for?
Your Honor, I was wondering if Mr. Lane would be all right with us doing, with us taking care of Mr. Dixon next. The officer has something going on that I'd like for him to be able to get back to as soon as possible.
Okay, are you ready, Mr. Lane, on Dixon?
Yes, Your Honor, and I'm up to speed now as well for Mr. Gonzalez, and I'll draft an appointment order and get it over to you after court, if that's okay.
That would be great. All righty, and so Deputy, if we could get Ismael Dixon, is that Mr. Dixon?
Yes, ma'am. Hello, Your Honor. Yes, Your Honor, we're on it.
Awesome, I see. Thank you very much. All right, now calling the matter State of Georgia versus Ismael Dixon. Warrant number 2024 WA0143, 2024 WA014884. 83 is public prohibited acts at the public transit and criminal trespass, as well as 2024 WA014885 terroristic threats. In this case, representing the state, Assistant Solicitor Tipton, representing the defendant is Attorney Lane, your witness, Assistant Solicitor.
Yes, Your Honor. The state would like to call the Zoom call Officer Cortez Harris. Officer Harris, if you would please raise your right hand. Do you swear or affirm any testimony you give today shall be the truth, the whole truth, and nothing but the truth, so help you?
I do.
Thank you, sir. You may lower your hand. Officer Harris, how are you employed?
With MARTA Police Department.
Being employed with the MARTA Police Department, are you post-certified?
Yes, sir.
Being post-certified, are you certified to make arrests and investigate crimes?
Yes, sir.
Right. Were you working on January 18th of 2024?
Yes, sir, I was.
Okay. And were you working at the airport MARTA station?
Yes, sir.
did you have occasion to make contact with the defendant, Ishmael Dixon?
Yes, I did.
Okay. And what did you observe Mr. Dixon doing?
Mr. Dixon proceeded into the fare gate behind another patron who had paid. And via MARTA policy, we asked them to go back out and tap their Breeze card and check their Breeze card as well. Mr. Dixon's Breeze card was checked on that day as well. And there were no trips or no balance on those Breeze cards. Mr. Dixon was asked to step outside of the fare gate and eventually also asked to leave. Mr. Dixon refused, stated that he didn't have time for this. And so we asked the last time and asked, so are you going to leave? Are you going to move? And Mr. Dixon said no. And so at that point, Mr. Dixon was placed in handcuffs.
I see. And did he make any threats
Yes.
during this?
Yes, it's the MARTA policy is that when after they are placed in handcuffs, we take them to an area similar to like a holding cell where they are searched. We particularly try not to do that in public, being that we are in very close quarters to other patrons. And so when we got into that, into the staff room holding cell area, Mr. Dixon was very combative as we attempted to search, even putting his feet up against the lockers and having to be taken down to the bench, which resulted in the use of force. And then after being placed in handcuffs, as seen in the report and on body cam, Mr. Dixon stated that he was going to beat us up, punch us in our face, black my eye, and other officers.
I see. Now, I want to go back to the start of this and take this down into each crime individually. Okay.
No problem.
Okay. So the first thing you saw was Mr. Dixon attempting to enter the MARTA station immediately after another patron. Is that correct?
Yes.
And would that is that consistent based on your knowledge, training, and experience with trying to essentially skip paying the fare?
Yes. Mr. Dixon initially saw us making conversation with another patron, walked past us. There were multiple officers there. And if we're facing the outer gate, proceeded into the far left gate, which would have been the first gate coming into the entrance. And so after a patron tapped their card, Mr. Dixon slid right in behind them and was approached by another officer who met them immediately.
And you mentioned checking his Breeze card. How do you check someone's Breeze card?
We go to the machine. We have the Breeze machines that are located at the entryway of the train stations. And then typically after we've gotten them in the staff room, after we've searched them, one of the officers will go and check the Breeze card to verify whether there was a trip or a fare on there. And so that was done by Officer Perry, and there was no fare on that Breeze card.
Okay, so to make sure I understand, there were no charges on the Breeze card from that day.
Correct.
Okay. And then you informed Mr. Dixon to leave and go back into the in order to come back in and pay. Is that correct?
Correct.
Okay. Did Mr. Dixon leave at that time?
No.
Okay. And at that point, he explicitly stated they didn't have time for that. Is that correct?
Yes.
And were you in uniform at the time?
I couldn't hear you.
Were you in uniform at the time?
Yes.
Okay. Did you identify yourself as a MARTA police officer?
Yes, we had multiple officers. It was about 5 of us.
And being a MARTA police officer, are you allowed to give criminal trespass warnings
Yes.
at MARTA stations? Okay.
Yes.
Okay. Do you see Mr. Dixon on the call today?
Yes. He'll be in the orange jumpsuit under the Clayton County Jail.
Thank you. Did all this occur in Clayton County?
Yes, sir. At the
Okay.
airport location.
And you mentioned that he threatened to do bodily harm to you and other officers. Is that correct?
Yes, myself and Officer Perry was also in the room. And
Were
it was
there-
also recorded.
Okay, so it was recorded and there were other officers in the room?
Yes.
Okay. And did he threaten to perform violence on you?
Yes. Punched me in my face. Stated that he would black my eye.
Okay. I have no further questions at this time. Thank you, Officer Harris.
Good morning, officer.
Good morning.
And so, when you first encountered Mr. Dixon, were you just by yourself, or how many officers were with you?
It was about 5 of us. Myself was outside of the fare gate, but we had 4 other officers inside the fare gate. Officer Perry and Officer Moore initially made contact as well, where everyone asked Mr. Dixon to step back outside of the gate, and Mr. Dixon refused. So we had multiple officers all in uniform right there. And the way the MARTA policy is typically if you just ask us, we don't mind helping. But there are people that blatantly bust through the gate in front of us, and that's why we asked them to go back outside the gate.
Okay. And if you were wanting to, I guess, get some credit on your Breeze card, do you have to go through the gate to do that, or is that
No.
other?
No, you
side?
would do that before you go through the gate, but there's a cashier. There's a cashier right there that Mr. Dixon walked past. There are actually 3 windows. So if Mr. Dixon did not have the correct amount of change, he would have been able to do so. He bypassed those. He also bypassed 6 machines to his left, 3 cashiers to his right to enter into the fare gate without paying.
Okay. And when you arrested him, I guess there was a search incident to arrest. Did you
Yes.
conduct that?
Yes.
Did you find any cash on him?
Yes, we found hundreds of dollars on Mr. Dixon, and we asked Mr. Dixon why didn't he pay, and he said he wasn't going to break his $100 bills.
Mhm. And when the officers, I guess that you said there was about 5 officers there that were in the area.
Yes.
Mr. Dixon, when you first encountered him.
Yes.
And how much of an opportunity or how long of a conversation was there between you all and him to give him fair opportunity to?
Well, if you watch with my body cam footage, I asked Mr. Dixon myself 6 times to step back outside of the gate. 6 times to be exact, where I said, ma'am, step back, because at that time we were not able to identify which gender Mr. Dixon was because he was dressed with long hair. And so out of respect, we asked. Later on, he did tell us how to identify, but we made direct contact, asked Mr. Dixon to exit out of the gate. I myself 6 times, other officers, I don't know how many times they did, but we directly approached Mr. Dixon and Mr. Dixon refused. He told us he was not leaving. He stated he did not have time for this. And the last question before putting him in handcuffs was, "Are you going to move?" And Mr. Dixon said no. And so that's why Mr. Dixon was placed in handcuffs. And that is also seen on my body cam footage.
And as far as his mental state, could you determine, was he able to understand your questions and commands?
Yes.
All right. All right. Thank you, officer. I have no further questions.
All righty. Closing arguments.
Yes, Your Honor. This is a simple cut and dry case for a preliminary hearing. We have a defendant who is charged with public transit violations. Specifically, he's accused of fare jumping. He attempted to sneak behind another patron to avoid having to pay for a fare. Further, once he was observed with that, he was observed doing that, he refused to leave and re-enter as stated by an officer that was on scene and that witnessed the entire event. That refusal to move was made by someone who was in uniform as a MARTA officer, who identified themselves as a MARTA officer, and after that point, the officer was threatened by Mr. Dixon, specifically stating that he was going to punch him in the face and black his eye. So for that reason, Your Honor, the state believes that there is probable cause and would ask the court to find probable cause.
All righty. Go ahead, Attorney Lane.
Just briefly, Your Honor, as for the fare jumping, I just never seen a case where an individual has hundreds of dollars on their person and is accused of fare jumping at the MARTA. Just to me, that kind of raises some serious question on what was going on as far as the opportunity or fair opportunity for Mr. Dixon to go ahead and pay the fare, and then it seems like from that point on things just kind of may have spiraled out of control. But just based on that, especially with the fare jumping, we'd request that charge be dismissed.
All right, based upon the evidence presented, I do find that there is sufficient probable cause to bind this case over to the state court of Clayton County. That's the order of the court.
Thank you, Your Honor.
I've had so many cases for theft where they'll go into Walmart and they'll have the money in their pocket. And I'm not sure why someone would take the risk, but I see it all the time, unfortunately. Maybe that's money for something else. I'm not sure. But at any rate, who would be the next one?
Your Honor, I believe that Attorney Lane informed us that he was ready on the Gonzalez matter. And if I may, Your Honor, Officer Harris, that was your only case for today, correct?
Yes, sir.
Your Honor, may we excuse Officer Harris?
Yes, Officer Harris. Thank you. Have a great day.
You as well. Thank you, Your Honor.
And so on Gonzalez, right? Okay.
Yes, Your Honor.
If you can get Mr. Gonzalez. Okay, so on Mr. Gonzalez, there was nothing you guys could work out on this. He doesn't have a criminal history at all. And the allegation of snatching a cigarette, he's been sitting in jail since December.
Your Honor, we'd certainly be willing to waive hearing if the state, I didn't have access to his criminal history just being appointed on the case too. But certainly under those circumstances, we'd be willing to waive hearing if Mr. Tipton would agree to a unsecured judicial release or OR bond.
Attorney Tipton, would you agree in this case where the inmate has been locked up since December 30th and it is now February 20th?
So, Your Honor, per the direction I've been given by my supervisors, we are not consenting to OR bonds at this time. But if, Your Honor would give me a moment, I will see if we can make an exception in this case.
Okay, go ahead.
Thank
said,
you.
You said you're gonna reach out?
Yes, Your Honor, I'm
Okay.
gonna reach out right now.
All right, thank you.
Your Honor, I've returned from speaking with Deputy Chief Ponder. May I be placed in a breakout room with Mr. Lane to discuss the conditions of an OR bond?
Yes.
Thank you.
Uh-oh, hold on.
All right, Mr. Tipton, I'm sorry, I missed that announcement.
I'm asking to be placed in a breakout room with you to discuss the conditions of an OR bond. If
Oh,
there-
sure.
Okay, and so Mr. Lane, you're already in room 1. Attorney Tipton, you're in room 1. I'll just be in recess.
Thank you.
Thank you.
And Judge, I had an announcement with, as far as Mr. Gonzalez, if I could, we could either do it here in court, or I could just briefly meet with him. Might be better if I briefly met with him to go over the conditions of bond.
Okay,
His
all right, so
release.
we can do that momentarily.
Yeah.
But we'll just move on. We'll know that that's gonna be a judicial waiver.
Okay.
And so just hold tight on that. Who can we do next?
Your
And
Honor,
then what we'll do, Attorney Lane, in between the next one, I'll put you in with the jail.
Okay, thank you.
All right. All right, and so who are we doing next?
Your Honor, that was the only other case that I had for that I request to be heard early, because Sergeant Malatia is he worked the night shift last night.
Okay, well, just tell me who we rolling with next.
Your Honor.
You want to start at the beginning?
That would work well, Your Honor. Let's if we could start with Bartlett, that'd be great.
Okay, and we have that officer, right?
Yes, Your Honor. Officer Cameron Jackson should be on.
Okay,
Your Honor, if I may have
Deputy-
one moment, I'm being paged by by my supervisor. If I may have one moment.
oh, okay, all right.
Your Honor, I apologize. I'm back from that brief page.
All righty. Okay, so now we're just waiting for Mr. Bartlett to be brought forward.
It looks like Mr. Bartlett is there, Your Honor.
You know, it's so many people on this screen until it keeps going to the next screen where I can't see it. Okay, there we are. All righty. Now calling the matter of State of Georgia versus Christopher Bartlett, charged in warrant number 2024 CW 70022, family violence battery. Attorney, oh, wait a minute. I lost everybody. Okay. All right, Assistant Solicitor Pippin, your witness.
Yes, Your Honor. The state's going to call Officer Cameron Jackson to the Zoom call. Officer Jackson, if you would please raise your right hand. Do you swear or affirm any testimony you give today should be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you. Please lower your hand. Please state your name for the court.
Officer Cameron Jackson
Thank you, Officer Jackson. Officer Jackson, how are you currently employed?
with the Clayton County Police Department,
I see. And what is your position there?
police officer.
And being a police officer, are you post-certified?
Yes, sir.
Being post-certified, are you authorized to do to inspect crimes, investigate crimes, and make arrests?
Yes, sir. That's correct.
All right, thank you. Were you working on January 5th of 2024?
It was January the 4th. Yes, sir.
I'm sorry, January 4th. You mean January 4th, 2024?
Yes, sir.
Okay. Were you dispatched to 9548 Brown Road in Jonesboro?
Jonesboro. Yes, sir.
Yes, sir. Is that in Clayton County?
Yes, sir.
All right, thank you. What took you to what was the occasion that you were responding to?
I was responding to a domestic situation. So when I had arrived on the scene, I made contact with Chrissy Pierce, which is the witness. She stated that her daughter and Mr. Bartlett had gotten into a verbal and physical altercation, and Gracie was walking behind. Well, Gracie stated that she wanted to lay down, but Bartlett wanted to spend time with her. Gracie stated that she was laying down at the moment, and Bartlett became irate because she didn't never move from laying down. And after that, she had Mr. Bartlett had said that he was going to destroy her items. So Gracie proceeded off the bed and followed behind Bartlett, and that's when I guess an altercation happened between the two, a whole bunch of yelling and screaming, and Bartlett had pushed her. And that's when Gracie had stated she was trying to catch her balance. And when she tried to catch her balance, Bartlett had closed the door on her foot. And after she closed the door on her foot, that's when Bartlett and Chrissy, the witness, had got into an altercation. And she stated she was going to call the police. And when she called the police, he left the location. And she stated he proceeded to run northbound on Brown Road, which I searched the area to see if I could locate him, but I didn't find him. So I ended up coming to the house and spoke with the Gracie and Christy. So after I spoke with the two, I noticed that Gracie had a limp. She was walking with a slight limp. So I asked her if she needed any medical attention. So EMS came out, they checked her out, they checked her leg, where her foot actually, her toes were swollen. EMS had said that her foot was sprained. No, her toes were sprained. Sorry about that. Her toes were sprained, and Bartlett wasn't at the location at the moment, so I ended up taking warrants on.
I see. Did you confirm that Bartlett lived at that location?
Yes. Gracie and Chris stated Bartlett stayed at the location.
I just want to go through and make sure that we've got all the parties straight. So you mentioned Christy and you mentioned Gracie. Who was the victim in the case?
The victim was Gracie.
And was Christy, was she the one who called you that day, or just the person you made first contact with?
Yeah, she called, and that's the first person I made contact with. Christy had called. She was the witness.
Okay, then. So I want to make sure I understand. So Christy, so per your testimony, Christy did hear Mr. Bartlett and Gracie getting into a verbal altercation. Is that correct?
Yes, sir. That's correct.
After that, you investigated and spoke with Gracie. Is that correct?
That's correct.
Okay. And from what you were told, Gracie then told, what did Gracie specifically told you, being that she's the named victim in this case?
Gracie had stated that she was pushed by Bartlett, which caused her foot to get trapped in the door when he slammed the door on her foot.
And you go ahead.
No, go ahead. That's it.
I got you. And you had and you did observe a visible physical injury?
Yes, sir. That's correct.
And what was the visible physical injury?
Her toes was swollen.
I see. Okay. Do you see Mr. Bartlett on this call?
Yes, sir. It's the individual with the orange jumpsuit.
Thank you. I have no further questions at this time. Thank you, officer.
Frost?
Hey, good morning, officer.
Good morning. How are you?
Hey, pretty good. So it's when you were interviewing Miss Gracie, she said that she was actually following Mr. Bartlett.
Yes, sir. She said she would follow him to make sure that he doesn't destroy any of her items.
Okay. So Mr. Bartlett was actually trying to get away from her.
Well, he was walking away.
Objection, Your Honor, that's speculation.
Sorry about that. Go ahead.
Go ahead, rephrase your question.
Is it true that Miss Gracie was following Mr. Bartlett?
Yes, he was following Mr. Bartlett, so he won't destroy any of her belongings that he stated that he did in the past. Authority wasn't called.
Okay. And so then when he retreated into the bedroom, he shut the door to get away from her?
He tried.
That's speculation, Your Honor.
Restate your question, Attorney Lane.
Okay, so he's walking or running towards the bedroom, is that correct?
He was walking towards the closet area. Yes, sir.
Oh, okay, and she's following behind him?
Mm-hmm. Yes, sir.
Okay. And he shuts the bedroom door?
He shut the door on her. He shut the door. He pushed it and shut the door on her foot.
Okay. And so she's charging into the room or through the door area at this time?
Yeah, she was walking towards the door area. Mm-hmm.
Okay. Did anybody happen to did the mother or anyone else get any kind of video of this?
No, sir. No video was obtained. I had the witness had stated that she heard a whole bunch of screaming and yelling, altercation going on between the two before she came.
All right. And is it fair to say then, with him slamming the door, that there wasn't any intent for him to injure her?
I mean, considering he had pushed her, there still was intent.
Okay, but as far as slamming the door, he's just trying to get away from her, correct?
That's correct.
I have no further questions, Your Honor.
All righty. Any redirect?
Briefly, Your Honor. Officer Jackson, did your investigation, based on your investigation, did Gracie appear to be the aggressor towards Mr. Bartlett?
No, not at all.
based on your investigation, did Mr. Bartlett appear to be the aggressor towards Gracie?
Yes.
Based on your investigation, did it appear that Mr. Bartlett did indeed intend to slam the door?
Yes.
Based on your investigation, did Mr. Bartlett intentionally make physical contact of a provoking nature with Gracie?
Yes, that's correct.
And what was the first insulting or provoking contact he made with?
The first contact he made was when there was a verbally arguing first, and then he pushed him.
I gotcha. And based on your investigation, did they both live at the same location?
Yes.
Did they both the room that they were entering, based on your investigation, was that Gracie's room?
Yes, that was a Gracie's room.
Thank you. I have no further questions.
All righty. Are we ready for closing arguments?
State's ready.
Yes, Your Honor.
All right, Attorney Tipton?
Yes, Your Honor. Your Honor, what we have here is we have a classic battery family violence situation. We have a situation where the defendant did intentionally make physical contact with the named victim in this case, Miss Gracie Pierce. First off, he made once he threatened to destroy Miss Pierce's belongings and then made his way towards that. Miss Pierce did have the right to go and gather her belongings or prevent him from destroying her belongings. Before he, based on the officer's testimony, there was no threatening. She was not approaching Mr. Bartlett in a threatening manner. Mr. Bartlett pushed her before he ever closed the door on her, which was an intentional touching, and then he intentionally shut the door, which, as Your Honor knows, the mens rea in this crime would be the intent to do the act that caused the battery, not necessarily the intent to cause injury. Specifically, when he intends to slam the door, whether it's slamming the door in her face, slamming the door in her foot, or slamming the door just to shut her out after pushing her down, that is intentional touching. Further, Your Honor, there was an injury, and that injury was specifically Miss Pierce's foot. It had swollen, it was visible. Ergo, we have the visible injury requirement. Lastly, Your Honor, the issue is whether or not they were living together at the time. The officer stated that both of the witnesses that were on the scene confirmed that they did live together at the time. For those reasons, the state believes that there is probable cause to bind this over to state court.
All right, so based upon the evidence presented, I do find that there is sufficient probable cause to bind this charge over to the State Court of Clayton County. That's the order of the court.
Thank you, Your Honor.
And that officer may be excused if he doesn't have anything else.
Oh, ma'am. Thank you, Your Honor.
Thank you, Your Honor. Thank you, Officer Jackson.
Thank you, sir.
All right, go ahead and tell me so let's go ahead and get ready.
Your Honor, next up would be Jacayla Bryant.
Yes, if we can get Ms. Bryant.
And Your Honor, I wasn't sure when Mr. Lane wanted to speak to his client, Mr. Gonzalez.
Okay, let's go ahead and take a moment to do that. That's fine. Deputy, if you would join, both of you guys can rejoin room 1.
Thank you, Judge.
All right.
All right, Your Honor, we had an announcement on Mr. Gonzalez.
Yes, hold on 1 second, guys.
Attorney Lane,
Yes.
In reference to the family class from Mr. Gonzalez, is it a form he will get on his way out for that? Whatever's going on.
Yeah, I believe, I don't know if it's probation or which.
With like an address or something on it in reference to that?
Yeah, and I don't know if Mr. Tipton.
Mr. Lane, may I cut in?
Sure, thank you.
So there are a list of approved providers that probation provides us. Mr. Lane, I will provide that list to you and you can pass that along to your client.
Okay.
Thank you.
All right, had to deal with an issue. Where are we now?
Yes, Your Honor, just making the announcement on Mr. Gonzalez. And the state and I have agreed to his release today. The conditions of bond, though, what they put in place is no contact with the victim, and then within 10 days of release, he's to enroll in a family violence class. I don't know if there's a way, if Mr. Gonzalez is going to be released today, to get him the information for the family violence. If there's a way to get that to the jail today, so he could give it to him when he was released, because getting it to me, I guess I could try to forward it to the jail. I don't know which would be easier.
All right, and so if someone could get that information to myself and a copy of my assistant, we will get it over there to the jail and to make sure that when he's processed out, he gets that information.
Yes, Your
Thank you,
Honor.
Judge.
I will send that to you right now, Your Honor. And Your Honor, just to confirm, Miss Lindley is your assistant, is that correct?
Lindley and Yatte, it says J.A. Yatte, and also Kimberly Lindley, yes.
Thank you, Your Honor.
All right, and I'll just wait for that order. All right, and who are we doing next?
Your Honor, I believe that would be Jacayla Bryant.
All right, do we have Mr. Now, who's that gentleman right there?
That's Mr. Gonzalez, Your Honor.
Mr. Gonzalez.
Oh, okay, all righty. Did you hear who we need next, Deputy?
I didn't, Your Honor.
That's gonna be Jacayla Bryant.
Bryant.
Yes, ma'am.
And Your Honor, may we release Officer Malete from the Maletia?
Yes, yes.
Thank you so much for coming in, Sergeant. You have a good day.
Thank you, Judge.
You're welcome. Have a good day. All righty, so now calling the matter of State of Georgia versus Kayla Bryant. Sergeant warrant number 2024 WA 01487, obstruction of an officer. 2024 WA 01488, another obstruction charge. 2024 WA 01489, simple battery on an officer. 2024 WA 01490, another simple battery on an officer. Representing the state is Assistant Solicitor Tipton. Representing the defendant is Attorney Lane. Your witness, Attorney Tipton.
Yes, Your Honor. State calls Officer N. Williams to the Zoom call. Officer Williams, if you could raise your right hand, sir. Thank you, sir. Do you swear or affirm any testimony you give today shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you. You may lower your hand. Officer Williams, please state your name for the court.
I'm going to be Officer Neil Williams, Jr.
Thank you. Thank you, Officer Williams. Officer Williams, how are you currently employed?
I am employed with the Riverdale Police Department in Clayton County, Georgia.
Thank you. And being employed with the Riverdale Police Department, are you, excuse me, are you authorized to make, or are you post-certified?
Yes, sir, I am.
Are you authorized to make arrests and investigate crimes?
Yes, sir, I am.
Thank you. Were you working on January 18th, 2024?
Yes, sir, I was.
Thank you. Did you have occasion to go to 578 Lassiter Street in Riverdale, Georgia?
Yes, sir, I do.
Okay. And is that located in Clayton County?
Yes, sir, it is.
And why did you arrive at that location, sir?
So from start to finish, I get dispatch out there until to a suspicious person call. Me and my Sergeant S. Kinsey, we arrive on scene and we make contact with two unidentified people, one male, one female. The moment we get out the car, the unidentified female at the time, who is Miss Bryant, she begins to walk away in a hurry. I go after her per my sergeant. I start giving her verbal commands to stop. She proceeds to walk across the street, continue to walk away from me in a hurry. Which at that point I run after her and I withdraw my taser, my department issued taser, and held Miss Bryant at taser point. Which at that time I gave a verbal command. She asked, "What did she do wrong?" And I noticed in her right hand she does have what was brought up to me a razor blade, a blade with a razor in it. I've never seen that before. So at that time, I'm telling her to drop it. She said, "What did she did wrong?" My partner, Officer P. Porter, arrives on scene and he withdraw his department issued firearm and holds Miss Bryant at gunpoint. So now we have her at taser point and gunpoint. I holster my taser.
Hold on. Hello. Who is speaking? Officer Williams up there?
Yes, Your Honor. It's Officer Williams. Just appears that
Yes,
he's
ma'am.
able-
Officer and
Oh, it appeared that you were still and your mouth wasn't moving. So I just wanted to make sure. I was like, well, maybe it's somebody else talking. I'm sorry. Go ahead.
Office, Your Honor, it appears
Yes,
that his
ma'am.
bandwidth is his bandwidth is low.
Just say that again.
It appears his bandwidth is low, so we're seeing a pretty severe lag.
Oh, that's what it is. Okay. All right. Carry on. My apologies.
Yes, ma'am. No problem. I'm sorry about that. So, Officer Porter arrives and he withdraws his department issued firearm, and we have Miss Bryant at taser point and gunpoint. She finally drops the razor knife, and I holster my taser and I go hands on and go to try to detain her. She begins to get combative. I get one cuff on her right wrist. She gets combative and slips out of the cuff. And as I go to cuff back the right wrist, the right hand, she turns and strikes me in the mouth. Officer Porter then holsters his firearm and proceeds to come over to help to get her left arm restrained. Prior to him getting the left arm restrained, she turns and strikes him in the mouth, causing blood. We then take her to the ground and get her restrained with hands behind her back and handcuffed, double locked. We get her up and walk her to the car, Officer Porter's car. We call Bergen County Communication to advise them to get Riverdale Fire Service into our location to give Miss Bryant medical attention, which at that time it's all on body cam. She did refuse and did not want medical attention.
I see. Thank you. You can give me one moment. I want to make sure I understand too, Officer Williams. So he struck another officer, Officer Porter, in the face, and you observed blood coming out of Officer Porter's mouth?
Correct. And he did advise that he was bleeding from the mouth. Once we had her detained in the rear of his patrol vehicle.
Let's see, and you mentioned a razor knife. Was it just a blade by itself, or was it like a retractable knife?
To my understanding and to what I observed, it was one of those like I guess you would say push knife, push whatever that is, razor blade, razor knife. It had a razor in it.
Like a box cutter knife.
If I'm correct.
I got you. In refusing to obey your lawful commands, did Miss Bryant obstruct or hinder your ability to perform your duties as a police officer?
Yes, she did.
In refusing to drop the knife, did she excuse me, did she obstruct or hinder your ability to perform your duties as a police officer?
Yes, she did.
Thank you. And did she make unwanted physical contact with you by did she make unwanted physical contact with you when she struck you?
Yes, she did.
And did it appear to be unlawful physical contact with Officer Porter when she struck him?
Yes, sir.
Okay. Do you see the defendant? Do you see Miss Bryant on the call here today?
Yes, sir, I do.
Identify her by what she's wearing?
She has on a green jumpsuit, a plaques in her hair.
I see. Thank you, officer. I have no further questions at this time.
All right, Cross.
Hey, good morning, officer.
Morning, sir.
When you arrived, you said there was a call of a suspicious person in the area?
Correct, sir. That's what I got dispatched to.
Okay, did you ever identify who made the call?
No, sir. So to my understanding, per my sergeant, he advised dispatch and dispatch advised that no 39. So the caller did not want to be known.
Okay. Was this like a neighborhood, or is this like an area where there's businesses at 578 Lassiter Street in Riverdale?
So 578 Lasher Street, the street right behind it is it is a neighborhood, but 578 Lasher Street exactly is a church.
All right. And when you arrived, was Miss Bryant committing a crime?
No, sir.
Okay. And the and so then when you encountered her, what happened next?
So when me and my sergeant and Porter arrived, when we encountered her, the moment we got out the car, it was a gentleman there. Prior to us getting there, I don't know if they were talking, but when we got out the car, she immediately looked at us and began to walk away. As I looked at my sergeant looked at her. That's the person. I gave verbal command for her to come here or stop, and she proceeded to cross the street in a hurry. She like a light jog per se.
So she never like was sprinting away from you, correct?
No, sir.
Okay. And based on your subsequent encounter with her, what was her mental state like? Did it seem like she was able to communicate effectively and understand questions and commands?
Yes, sir. Yes, sir.
And did you have your body cam on during this encounter?
Yes, sir.
Okay. And when you first arrived at the scene, how were you able to identify her? Or I guess you get this call, this real general call of a suspicious person in the area. I guess what was suspicious when you arrived?
So to me, nothing was suspicious. Only I would say the place of business was closed. It was a church. There was no one there. The place of business was closed. The church was closed. Like I said, when we got there, I don't know what happened prior, but as we got there and we got out the car, she immediately looked at us and began to power walk away. After, like I stated, after looking at my sergeant and looking at her, I gave her verbal commands to come here, and she proceeded to like quickly jog away across the street.
Thank you, officer. I have no further questions.
All righty, any redirect?
Thank you, Your Honor. Officer Williams, as a post-certified officer, are you authorized to make brief investigatory stops?
Yes, sir.
Are you able to question passersby when you have suspicion that there may be a crime, or when you are called out to investigate the safety of an area?
Yes, sir.
Would this be one such instance where you would have made brief contact with someone to identify whether an area was safe?
Yes, sir.
Okay. When you made contact with Ms. Bryant, did she verbally respond to you?
Yes, sir. At one point, she did. Yes, sir.
I gotcha. You mentioned that she had a box cutter knife in her hand, and you told her multiple times to drop her knife. Would that have been a command made for officer safety purposes?
Yes, sir.
If you would have noticed the knife when you first arrived, would you have made the command for her to drop the knife for safety reasons?
Yes, sir. I would have.
Thank you very much, officer. I have no further questions.
Closing arguments. Attorney Tichner?
Yes, Your Honor. Go ahead. Your Honor, on this date, we have an officer who is doing a safety check in an area of a closed church. During that safety check, he gave a lawful command to someone to essentially ensure that the area around the church was safe. When he made contact with that person walked away. He continuously attempted to make contact with her, at which she just began walking faster. Right there we have one attempt to obstruct or hinder the officer. The second obstruction is when he stated that he told her to drop her razor knife. However, she did not drop her razor knife. She continued to hold that. That would have been a command given for officer safety, which in fact obstructs or hinders officers. The legislature of Georgia has specifically stated in the obstruction statute, and that's OCGA 16-10-24, that they intentionally left the obstructing or hindering law enforcement officers statute vague in order to encompass a wide variety of things, because the only requirement is that the defendant obstructs or hinders law enforcement officers in the official as they're performing their official capacity of their duties. With regard to the simple battery, we do have a situation in both cases where after the officer arrived in his patrol vehicle and identified himself as an officer, he attempted to place Miss Bryant in handcuffs. Miss Bryant turned and punched him, and then turned and punched another officer, which he witnessed. For those reasons, Your Honor, the state believes that there is probable cause and would ask the court to bind it over to state court.
Attorney Lane?
Thank you, Your Honor. We just request dismissal of both of these charges. This was all brought on by the officers. Escalating the matter, it's brought on by an illegal arrest. You heard the officer testify when he arrived that not only was there not a crime being committed, there was nothing suspicious going on. Nobody to date, from what I can tell, was been injured, or there was no robbery of the church, or nobody was harmed outside the church. And so you just simply have my client minding her own business and happens to be walking around in the area. And so not committing any crimes, not being suspicious. And so just based on that, we'd request that anything that escalated or any crimes allegedly committed from this encounter be dismissed.
All right, based upon the evidence presented, I do find that there is sufficient probable cause to bind all the charges over to the state court of Clayton County. That's the order of the court.
Thank you, Your Honor. Officer Williams, is that your only case today?
Sorry, yes, sir, that is.
All right, Your Honor, may we excuse Officer Williams?
Yes. And so are we doing Dixon next?
Your Honor, I believe we've already done Dixon. Yeah, that was one of our officers that had to go early.
Okay, all righty. And then, so who do you have who do you have next?
And that's transferred. Your Honor, next would be Eric Jones with Officer Oliver.
Okay, can we get Eric Jones, deputy, please? All right, are we ready to proceed? All righty, now calling a matter of State of Georgia versus Eric Jones, charged in warrant number 2024 WA-01456, battery family violence, representing the state assistant solicitor Tipton, representing the defendants, Attorney Mark Lane, your witness, Attorney Tipton.
Yes, Your Honor. State's going to call Officer C. Oliver to the Zoom call. Officer Oliver, please raise your right hand. Do you swear or affirm any testimony you give today shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you. Officer Oliver, how are you currently employed?
I'm a patrol officer with the city of Jonesboro.
Thank you. Being a patrol officer, are you post certified?
Yes, sir.
Being post certified, does that give you arrest powers and the ability to investigate crimes?
Yes, sir.
Okay. And were you working on the day of January 17th, 2024?
Yes, sir.
And were you called to 8140 Terra Boulevard in regards to a domestic disturbance?
Yes, sir.
Okay, can you explain to me what occurred that day?
That morning we were dispatched to the Quick Trip on Terra Boulevard, North Avenue, in regard to a domestic disturbance that took place at the motel next door. Upon arrival at the Quick Trip, we met with the victim, that was Ms. Johnson, and she stated that her husband had put her out, and she was very upset. She said that she had been choked and she had been hit, and her friend was downstairs waiting for her and drove her to the Quick Trip so that she called police. While speaking with Miss Johnson, I called an ambulance to come check her out to make sure that she was okay. She also expressed to me that she was pregnant. So with that circumstance, we wanted to make sure that she was okay and didn't need any further medical attention. I did notice that she had a bruise on the left side of her face, and she said that she had been choked. I didn't see at that time any marks or bruises on her neck or in her upper torso area. And after she was cleared by the EMTs, myself, Sergeant Uppel, and Officer Watts went over to the hotel room where her and her husband were staying. We made contact with Mr. Jones and had a conversation with him. He stated that his wife was asleep, and then she woke up. They began arguing, and she started packing her things to leave. There was someone waiting for her outside, and she left. Due to Georgia state law, domestic violence readings and the evidence that she had of the bruise on or the markings on her face, along with the witnesses' statement that he was outside and heard what he believed was a smack immediately after them arguing, Mr. Jones was arrested for battery.
Okay. You just mentioned a third-party witness.
Yes,
Before we go any further, we also mentioned that the initial incident was at 8240 Terra Boulevard and room 216 in Jonesboro. Is that correct?
Yes, sir.
Is that within the bounds of Clayton County?
It is.
Okay, thank you. And I want to go back now to this third-party witness. Was that Mr. Calvin Nunn?
Yes, sir.
Okay, and Mr. Nunn, to the best of your knowledge, had no contact or ties with either Miss Johnson or Mr. Jones. Is that correct?
No, sir.
Okay, and what did he inform you he had heard?
I'm sorry?
What did he inform you that he had heard?
He said he heard what believed to be a smack sound, and he demonstrated by clapping his hands. He said that he didn't see anything, but that's what he had heard and believed it to be a smack.
I see. And you mentioned that you saw an injury on Miss Johnson. What was that injury?
It was on the side of her face, the left side of her face.
I see. And would that have been consistent with being slapped?
Yes, sir.
I see. And did she tell you where she was slapped?
She was not very streamlined in her order of events, and when I asked her what were her injuries, I went through a very specific course of questionings that we have when domestic violence is involved. And they instruct me to ask her very specific questions. Upon the specific questioning, she did say that Mr. Jones took his right hand and smacked her on the left side of her face.
And she was pregnant at the time?
She did express to me that she was 6 months pregnant.
Okay. And they both confirmed that they were married. Is that correct?
Mr. Jones and Miss Johnson, yes, sir.
Those are all the questions I have for you. Thank you, officer.
Hey, good afternoon, officer.
Hello.
So you're speaking with Miss Johnson. Did you detect an odor of alcohol?
Yes, sir.
And did you request that she take an Alka-Seltzer test?
Yes, sir.
And she declined?
Yes, sir.
Okay. And you didn't observe any markings on her neck or upper torso, correct?
No, sir.
And when you were speaking with my client, Mr. Jones, did he take an Alka-Seltzer test?
He did, sir. Miss Johnson said that they had both been drinking and said that Mr. Jones had been drinking well after she went to sleep and suggested that he woke up or woke her up drunkenly.
Okay. And what was the results of Mr. Jones's Alka-Seltzer test?
They were negative.
Okay. Meaning that he was sober?
It was a negative reading.
Okay. And when you were talking with Mr. Jones, he denied putting hands on Miss Johnson?
Yes, sir.
Okay. And the witness, I guess, that you interviewed again, they didn't see anything, correct?
No, sir.
Okay. All right. I don't have any further questions. Thank you.
Yes, sir.
Director Attorney Tipton.
No, Your Honor.
Closing arguments, Attorney Tipton.
Yes, Your Honor. Your Honor, this is a simple matter of battery family violence. In order to prove battery family violence, we have to show that there was an unwanted or offensive touching that left an injury on someone who is either married to between parties that are either married, share children, or live together. Here we have two parties that confirmed that they were married. There appeared to be an unwanted touching based on what the victim said, and there was evidence of that touching in the form of a physical injury on that person. For those reasons, Your Honor, we believe that this would be this would in fact be a battery family violence, and would ask that the court find reasonable probable cause for this case.
All righty. Attorney Lane.
Yes, Your Honor, we request dismissal of the battery family violence charge. There's no probable cause here to prove that because the only witness, the alleged victim in the case, had alcohol on her breath, refused to take an Alka-Seltzer test, whereas my client took the test, was found to be sober. The test results were negative. So in a he said, she said situation, we would go with his version, which is, again, he said he never put hands on her at all, and would request that based on that the battery charge be dismissed.
All right, so I'm not sure how this got missed earlier, but this battery case should have been upgraded to a felony.
Yes, Your Honor, based on the choking.
Based on his criminal history, he has several convictions, battery convictions. Starting in way back 1998, he had one. Pretty lengthy. He had another one in 2017. Another one in 2018. Another one in 2018. And then this one. So he has about 4 or 5 battery convictions.
Your Honor, I see that now.
So this really needs to be transferred to Superior Court.
Yes, Your Honor, I'll have that placed on. I will inform my office manager and we'll let the Superior Court know immediately.
Okay, and so are you going to compose a proposed order?
I could, Your Honor, I could have that sent to Your Honor's office after court.
Okay, I'll just wait for that proposed order.
Your Honor, does this case need to be put on the prelim calendar for Superior Court?
No, he doesn't. We've actually had the hearing. They're going to send a proposed order.
Yes, and Your Honor, if that's the case, then we would need Your Honor to find probable cause in this matter, and then we would
Yes.
submit it through.
And I do find sufficient probable cause to bind this case over to the Superior Court of Clayton County. That's the order of the court.
Thank you, Your Honor. Your Honor, may we excuse Officer Oliver?
I'm sorry?
May we excuse Officer Oliver?
Yes, yes. And so
Officer-
who are we going to do next?
Thank you, Officer Oliver.
Thank you.
Next should be Jaleel Jones.
Yeah, if you can get Miss, I'm not sure that's a Jaleel. Yes, could you get inmate Jaleel Jones? We're done with that inmate deputy.
And Your Honor, State's going to call Officer Pickens to the Zoom call.
Say that again.
State's going to call Officer Pickens next. Just want to make sure Officer Pickens is up and ready to go.
Oh, okay. All righty. All right, we'll just wait for the inmate. We're almost ready. Oh, wait. I'm sorry, that was in Jones. Six. Okay, so are we just waiting on the deputy with the inmate?
That's my understanding, Your Honor.
Okay. And then Attorney Lane on Eric Jones, just so that I understand that he's probably gonna have some questions. I just want you to know that we are not referring to, there was one simple battery family violence that was dismissed. And so I am not referring to that one. So I know that, oftentimes they'll say, oh, that was dismissed, but I am not taking that one into consideration.
Okay.
All
Thank you for
right.
clarifying that.
Thank you. All right, looks like we have the jail.
What'd you say, Your Honor? I'm sorry.
All right, so now we are. Is that Mr. Jaleel Jones? Deputy?
Eric Jones.
No, we've already done Eric Jones.
Was it bounded over? Our computer got messed up, but we just got back.
Yes, PC was found,
Okay, thank you.
and then now we go to Jaleel Jones.
And Your Honor, just so the court's aware, the way that we're gonna handle Mr. Eric Jones is, what I think would be most expeditious is if we go ahead and send it up to state court, and then I can do an internal document just to send it upstairs at that point to Superior Court.
Okay, and I did on my PC, I did notate the upgrade pursuant to 6523.1 F2. So I've also put that on my prelim order.
Thank you, Your Honor, and I'm sending a request to have that file sent up to us immediately so that we can get that transferred without any delay.
Okay. All right, so now calling the matter of State of Georgia versus Jaleel Jones. Warrant 2023 CW 50388, charged in criminal trespass. That is the only charge. Representing the state is Attorney Attorney Assistant Solicitor Tipton. Representing the state is Attorney Mark Lane. Your witness, Attorney Tipton.
Yes, Your Honor, the state's going to call Officer Uriah Pickens. Officer Pickens, please raise your right hand. Do you swear or affirm any testimony you give today shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. Please lower your hand. Please state your name for the court.
Officer Pickens.
Thank you, Officer Pickens. Officer Pickens, how are you currently employed?
Clayton County Police Department.
And are you post-certified?
Yes, sir.
Being post-certified, are you certified to investigate crimes and make arrests based on your findings?
Yes, sir.
And were you working on January 25th of 2023?
Yes, sir.
Did you have occasion on that day to go to 8271 Attlebrook Drive?
Yes, sir.
Is that within the bounds of Clayton County?
Yes, sir.
Thank you. Why were you called that day, sir?
I believe we got a call out that was it came out as a burglary as a residence. And yeah, we responded to it to investigate that particular incident.
And when you arrived on the scene, did you make contact with the victim?
Yes, sir.
Okay, what did the victim tell you?
The victim advised me that he received notice from his daughter, who was not on scene, that she was looking through the security camera and seen several males on the residence attempting to make entry into the residence and also into the garage behind the residence. And due to that, she called her father, which is the victim that I actually made contact with, her father.
I see. And what time of the day did she say she saw the defendants at the residence?
If I'm not mistaken, it was early in the morning, probably around like 5 or 6.
And was this a public? Was this a public place or was it a private residence?
It was a private residence.
Okay. Was it a house?
Yes, sir. It was a house that also had a chain fence around it.
Let's see. Did the did the victim show you any videos relating to the incident?
She did.
Okay. And what did those videos have on them? What did you observe on those videos?
On the video, you can see 2 males dressed in hoodies and other clothing entering upon the premise of the house itself. And in one of the videos that were shared with us is one of the gentlemen that was on the video actually lifted up one of the cameras on the garage and clearly showed their face and who they were before attempting to enter into the garage once more.
I got you. And the complaining victim, was that Lynn Levins?
It was.
Okay. And did Mr. Levins, let's see, come to the property? And you mentioned earlier, Mr. Levins came to the property later that day, right?
Correct.
Okay. And did he, see, and did he inform you that they had, in fact, entered the home?
He said that there was no signs of any forced entry. However, they did enter into the land and also into the garage. However, nothing was taken.
I see. And did he state that he made contact with another witness?
Correct.
And what did this other witness tell you about the video?
I believe that witness went by the name of last name Mr. Hudson. Mr. Hudson, after looking at the video, actually advised us that the male on the video who clearly showed his face was in fact his roommate who stayed at a house directly across from the incident location. And from Mr. Hudson, he was the one who identified Mr. Jones.
And did you also make contact with a witness named Jennifer Crow?
Correct. It was her residence about who we went to question originally about the video, and that's where Mr. Hudson, while also being at that residence, both confirmed the person across the street was Mr. Jones, who was seen in the video.
Okay. And did you meet with them at 2 different times or at the same time?
At the same time.
And did they both confirm the identity of the witness? I mean, of the defendant?
Yes, sir.
Okay. Who did they identify him as?
They identify him as Mr. Jalil Jones.
I see. Did they initially identify him as a nickname?
Yes, sir.
What was that nickname?
If I'm not mistaken, it was Yeller.
Okay. And I want to confirm, did they state that Yeller did live at 8280 Attleboro Drive?
Correct.
Did you, and they did confirm that that was the nickname of Mr. Jalil Jones?
Correct.
Okay. Okay, were you able to confirm Mr. Jones's identity through were you able to identify Mr. Jones's identity in any way?
Yes, sir. I took his name and date of birth that was provided to me, and I ran it through our central database. And through that, I was able to run his name and date of birth and kind of match it up to ensure it was in fact Mr. Jalil Jones.
I see. And did you look that up through GCIC?
Yes, sir.
What is GCIC?
GCIC is our national database who holds and withtells general information about anybody that we pretty much look up in regards to their name and date of birth, which also shows a identifying picture of that person itself as well.
Okay, so did the picture appear to be the same person that you saw on the camera?
Yes, sir.
Gotcha. Did it appear that the household itself was so you mentioned that there was a fence around the home, is that correct?
Correct.
Okay. Was there anything that implied that this home was open to the public?
No, sir.
One quick second. Were there any signs displaying no trespassing?
I'm not sure, to be honest.
Okay. And based on your knowledge, training, and experience, do people often go into empty homes for unlawful purposes?
Yes, sir.
All right. Thank you. I have no further questions.
Ross?
Good afternoon, officer.
Good afternoon.
It's the video, I guess when you met with Miss Lynn Lovins, was this video that she had video on her phone, on her smartphone?
I believe Mr. Levins was the male that I met with. It was his daughter, who sent over the security footage to his phone. And from his phone, I seen that security footage.
Okay, so this was on security cameras outside the house?
Correct.
And how many males were seen on the security camera?
2 males.
Okay. And how were you able to identify Mr. Jalil Jones then between the two?
Well, on the video, one of the males very distinctively lifted up their face, where their face could be seen with no question on that said video. And that's how I was able to identify him with the help of the witnesses.
Did both males go into the garage?
I can't recall.
Okay. Did you ever interview Mr. Jones to get his version of what happened?
I did not. He was not at the scene on that date.
And as far as you know, since he's been arrested, has he ever been interviewed?
I've never had contact with Mr. Jones.
Could you tell, looking at the place in particular, the garage, did it look like any kind of work was being done, like any construction or remodeling or painting of the garage or the house?
To my recollection, no, sir.
All right. And there weren't any signs of burglary or breaking and entering?
There were no signs of forced entry, no, sir.
And nothing was stolen?
No, sir.
Okay. I don't have any further questions.
All righty. Any redirect?
No redirect, Your Honor.
All right. Closing arguments?
Yes, Your Honor. Your Honor, what we have here is we have a pretty straightforward criminal trespass. In order to have a criminal trespass, the state need only prove that the defendant knowingly and without authority enter upon the land or premises of another for an unlawful purpose, enter upon the land or premises of another when they knew or should have known that entry was forbidden, or entered into the or remained on the land of another person when they were told to depart. Mr. Lovins was not present when Mr. Jones was there. Therefore, the state would have to show that there was either an unlawful purpose or possibility of an unlawful purpose, or that the defendant knew or should have known that entry was forbidden. Specifically, now I think that the issue that we need to really focus on here is whether or not he knew or should have known that entry was forbidden. This was a private home. This was a situation where it was 5 a.m. The defendant walked over to the home and immediately turned a Ring doorbell camera away from him. It was not his home. It was a home that was owned by someone who was not present at the time. Therefore, he walked in, knew that he should not have been there. Therefore, he turned the camera away from him to avoid being seen on the security camera, ironically showing his face. And he was identified based on his nickname and the positive identification by two independent witnesses who recognized him, including someone who lived with him. Further, Your Honor, it's very likely that there was an unlawful purpose. So even if the state does not even if the state does not show probable cause based on knowledge that such entry should be forbidden, the fact that he was in there at 5 in the morning and with multiple people hints that there may have been an unlawful purpose that occurred. For those reasons, Your Honor, the state asks that the court find probable cause in this matter and bind it to state court.
All righty, Attorney Lane.
Your Honor, yes, we request dismissal of the trespass charge. The officer testified that there wasn't, he couldn't tell us whether anyone ever entered the garage, and certainly not my client. Additionally, there wasn't any signs of any kind of criminal activity, a burglary, or any kind of breaking and entering, or anything being damaged or missing. And so just based on that, we request dismissal of the trespass charge.
All right, so based upon the evidence presented, I do find that there is sufficient probable cause to bind this case over to the state court of Clayton County. That's the order of the court.
Thank you, Your Honor. I believe that is Officer Pickens' only case. May he be excused?
Yes, thank you.
Thank you. Thank you, Officer Pickens.
Thank y'all. Y'all have a good one.
Thank you.
And so I guess we're doing Laurie next, Kaden.
Yes, Your Honor.
Deputy, if you can get Kaden Laurie.
This is Mr. Laurie, Your Honor.
Okay. All right, calling the matter of State of Georgia versus Kaden Laurie, 2024 WA01401. Simple battery on an officer representing the state, Attorney Tipton, representing the defendants, Mark Lane. Your witness, Mr. Tipton.
Yes, Your Honor. It's going to call Deputy C. Wilson. Deputy Wilson. And we had Deputy Wilson on earlier.
I'm
Deputy-
here, sir.
Oh, thank you. Deputy Wilson? Okay. Would you please raise your right hand? Do you swear or affirm any testimony you give today shall be the truth to the best of your to the truth to the best of your knowledge, so help you God?
I do.
Thank you. Please lower your hand. Please state your name for the court.
Deputy Candace Wilson,
And Deputy Wilson, how are you currently employed?
Clayton County Sheriff's Office.
And are you post certified?
Yes, sir.
Being post certified, do you have the authority to make arrests and to investigate crimes?
Yes, sir.
Were you working on January 14th of 2024?
Yes, sir.
Okay. Did you have occasion to let's see. And on that day, were you assigned to the Clayton County Sheriff's Office Tactical Patrol?
Yes, sir.
And were you called to the Clayton County Jail on this day?
Yes, sir.
Okay. And were you called to assist in Housing Unit 4?
Wait, repeat that one more time. I'm sorry.
Were you called to assist in Housing Unit 4?
Negative. No, sir.
Oh, I see. Excuse me. I see. Oh, excuse me. I see the fight started in Housing Unit 4. My apologies.
Okay, wait. So this is a jail case?
It is, Your Honor, but it's not it's not a jail fight.
I'm sorry?
I believe it's not a jail fight. Actually, let me take a look at this.
The statute says any act of violence.
Oh, and it's a simple battery. My apologies, Your Honor. Yes, it is a simple battery family violence, so we'll need to transfer this one up.
Yeah, this case needs to be transferred to Superior.
Yes, my apologies.
Your Honor, if I could, just for clarification, that the incident report refers to an Oliver Lowry. And I'm showing on my paperwork a Caden Lowry. I'm just trying to make sure we've got the right.
Wait a minute, I'm looking at Caden Lowry. Am I looking at the wrong person?
No,
That's
Your
who
Honor. It is Caden Lowry.
And then
It is.
the warrant intentionally makes physical contact of an assaulting manner
Yes, Your Honor. My
against
apologies.
a police officer, correction officer.
That is correct, Your Honor. State will move to have this heard on the Superior Court calendar.
Does the incident report refers to an Oliver Lowry? Is that the same as a Caden Lowry?
What are you seeing with I don't see anything with Oliver. What are you looking?
The incident report?
Because I don't get that. I just get the warrants.
Your Honor, I have that it's that inside of the so in the police report it actually says Oliver Lowry, not Caden Lowry. It says Oliver did not comply. Let me see. That may be
Is that a scrivener's error?
Let me take a quick look, Your Honor. I'm gonna see if there.
And I don't know if we could ID him with his inmate number. I don't know.
We could.
I've got that. At least I see an inmate number in the report referring to an Oliver Lowry.
And I have that is Caden Lowry. Let me see if Caden Lowry and O'Carr. Let me look and see. And there is no record of an Oliver Lowry ever being in the Clayton County Jail. It was most likely just a scrivener's error.
Okay. But wait a minute, hold on. All right, and so, hold on. Let me go in the breakout room with councils, please. On this one. I will, hold on. All right, you guys can just join and I will join as well.
Your Honor, just for this case, or did you need all of this? Okay.
Finally, my turn. Cogdale, I warmed up my food already. He had came by. But the thing is messed up. It's probably gonna get thrown out because The name the sergeant gave me, Sergeant Hagan gave me, that's not even the right inmate.
Deputy Candace, you are not on mute. Can you mute yourself?
All right, so Ms. Thomas, if we could please continue this case to the next available prelim calendar, felony prelim calendar for Mr. Laurie Kane. I would say, let's put it on,
Do you also want to do that one on March 6th as well?
on what day?
March 6th?
March sixth? Yes, that's fine. So Laurie. Let me see. Okay, all righty. All righty, and so now let's,
Your Honor, may I dismiss, Deputy Wilson?
Yes.
And, thank you. And, that date for her to come back was March 5th. Is that correct?
March sixth.
March 6th. Thank you,
Yes.
Deputy Wilson. You have a good day.
Thanks. All right, thanks, you too.
And I guess we can, and if we can also make sure that we have, the public defenders need to know that to have that case prepared. So we need to reach out to the public defenders as well, Ms. Thomas. So that will only, today is the 20th.
Yes, Your Honor.
I get that should be enough time. Okay. And so we need to just make sure that the council is appointed as well. Okay. All right, so you want to go ahead and who are we doing next?
Your Honor, that's gonna be, Corey Myers with Officer S.Y. Doss.
You say Corey Myers?
Yes, with Officer, I believe it's Sycott Doss.
Okay.
Your Honor, this is the jail. Your Honor, this is the jail.
Yes,
Matthews, is he to remain? Inmate Matthews.
yeah, he can go back, right? Yes, he can go back.
And he was reset for another, yes.
I believe he's gonna go on the March 6th calendar. for
Yes,
felony.
ma'am. Yes, ma'am.
All right, thank you. All righty. Is this Mr. Corey Myers? All right, so now calling the matter of State of Georgia versus Corey Myers, 2024 W801395 from the trespass damage to property, 2024 WA01396 criminal trespass. Attorney Tipton, your witness.
Yes, Your Honor. The state's going to call Officer Sykot Doss to the Zoom call. Officer Doss, could you please raise your right hand? Do you swear or affirm any testimony you give today shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you. Please lower your hand. Please state your name for the court.
Officer Sykot Doss.
Oh, thank you, Officer Doss. Sorry for mispronouncing your name earlier.
No, it's okay. Everybody gets it wrong. You're not the only one. It's okay.
Thanks. Okay. Officer Doss, how are you employed currently?
I am a patrol officer for the City of Forest Park Police Department.
I see. And being a patrol officer for Forest Park, are you post certified?
Yes.
Being post certified, are you certified to make arrests and investigate crimes?
Yes, sir.
Were you working on January 14th of 2024?
Yes, sir.
Did you have occasion to go to 1466 Rock Cut Road, which is the Willow Park Apartments in
Yes.
Forest Park, Georgia?
Yes, sir.
Is that in Clayton County?
Yes, sir.
Why did you report there, sir?
On that date time, I was dispatched to 1466 Rock Cut Road, apartment Peepaw 2, in reference to a disturbance. Upon arrival, I met with the homeowner who stated that her son busted her window out and was not supposed to be inside the residence at that time.
I see. Did she inform you that she informed him not to that he was not to return at that time?
Yes, sir.
Okay. And when you mentioned that her window was busted, did you observe the busted window?
Yes, sir. And I observed the shattered glasses on the outside of the residence as well as inside the residence by the kitchen floor area.
Let's see. Did the victim show you any pictures of her son?
No.
Okay.
She didn't.
But were you able to identify? But she did give you the name. Is that correct?
Yes, sir.
Were you able to, based on that name, were you able to pull up a mugshot of him?
I was able to pull up the picture based off my GCIC when I entered his name and date of birth and information.
Okay. Do you see, based on what you saw on his GCIC, do you see him on the call today?
Yes, I do.
Okay. Can you identify him by an article of clothing he's wearing?
Yes, sir. He's a black male wearing a orange jumpsuit.
Thank you. So just to confirm, he was the complaining witness told you that the defendant was not allowed on the property at that time. Is that correct?
That's correct. She stated that he does not live in that residence.
Okay. And did she also state that the window was busted?
That's correct.
And did she inform you and did she say that she had given him any consent to break her window?
No, sir. She did not give him any consent.
Okay. And you did observe that window being broken, is that correct? Or you did observe
Yes.
that window was broken, is that correct?
Yes, sir.
All right. Thank you. I have no further questions.
Alrighty, Cross.
Thank you, Your Honor. Officer Doss, good afternoon.
Good afternoon, sir.
With whom did you speak at the apartment?
I spoke with the victim, Miss Sequel Henderson, which is Mr. Corey Myers' mother.
Okay. And did she describe to you how the window was broken exactly?
So when we got the call, she stated that she was in her room. She remained locked in her room because she stated that her son busted her window out and stated that she was not supposed to be inside the residence.
I see. Did she state any way in which the window was broken, like with a fist, with a rock, with a broom, anything?
No, she didn't specifically specify, but Mr. Corey Myers did admit to busting the window out with his hand.
Did you observe any damage to his hand?
No, I did not.
And as far as him being trespassed, to your knowledge, he was told to not be at the residence. Is that right?
Correct.
And he was told that by his mother. Is that accurate?
That's correct.
I'm sorry. Thank you. And do you know he wasn't there when you arrived, correct?
Oh, he was. He was inside. Actually, he was inside the residence when we got there. He was in the residence, inside the residence, taking a shower after he busted the window and everything out.
Did she tell him to leave at that? When did she tell him to leave?
When he busted the window out, she advised him that he's not supposed to be here, supposed to leave out, and he never left out the house. He refused.
Do you
And that's
know?
when she ended up force part.
I'm sorry. Do you know if he pays rent or is prior to this was a normal lawful resident of that apartment?
Not to my knowledge, sir.
The apartment, do you know if it belongs solely to his mother?
That's correct.
Did you ask him if he had lived there or established a residence there?
He advised to me that he does not live there. He stated that he was homeless, and he stated that it was too cold. He was sleeping in the car. It was too cold. He needs a place to stay, to be warm.
I see. Is it correct to say that the trespass was not due to being trespassed from a previous occasion, but rather due to the mother telling him to leave just prior to your arrival? Is that?
Yeah. I'm sorry. Say it one more time.
The question is, the trespass is not based upon a previous incident on another day, but rather her telling him to leave that evening. Is that what you're saying?
So she stated that he hasn't been living in that residence for a good little while. So he returned back after she had told him that he's not supposed to be inside that residence, but he still remained there.
Had she previously told him, to your knowledge, had she previously told him to leave prior to this date, or was it simply on this date in question, she wanted him to leave because of what he supposedly did? Does that make
Not
sense?
to my knowledge. Just it was just based upon that day. Not to my knowledge, any other time. This is my first time coming in contact with that current address.
I see. And do you know when in their interaction, whether as soon as he broke the window or as he was taking a shower, do you have any idea when she told him to leave that evening?
No, I don't recall that day. I don't recall that moment.
Okay. Thank you, officer. No further questions, Your Honor.
Any redirect?
Yes, Your Honor. Officer Doss, I just want to make sure I understand this. So did Mr. Myers admit to you that he broke the window?
That's correct.
Okay.
While placing him in handcuffs, that's when he admitted. He was like, I broke the window.
Okay. And Miss Henderson, she specifically stated, excuse me, she informed Mr. Myers that he was not not allowed on the house in the apartment after the window was broken. Is that correct?
Correct.
And did he remain on the premises afterwards?
Yes, sir.
All right. Thank you. I have no further questions.
All righty, closing argument.
State will submit on the facts, Your Honor.
All right, based upon the evidence presented, I do find that there is sufficient probable cause to find both charges over to the State Court of Clayton County. That's the order of the court.
Thank you, Your Honor. Officer Sakat Das, I believe that that's your only case. I think your brother's on for the other case. So you,
Yes, sir.
Your Honor, may I release Officer Sakat Das?
Yes, thank you, officer.
Thank you. You guys have a great day.
Thank you as well.
Bye-bye.
Your Honor, Mr. Thrash, is he okay to leave, ma'am, or?
On who?
Mr. Thrash.
Yes, he's free to go.
Thank you, ma'am.
Yeah.
All right, so who are we going next?
Your Honor, I need to check with my investigator real quick. We've been in contact with Mr. McFadden, with Officer McFadden previously, but for whatever reason, I don't think he made it onto the call. If we could, I'm gonna see if my investigator can check on him one more time.
Or can we just go with somebody that's already here and waiting?
Yes, Your Honor, of course. Let's see, we've got.
If your office can continue trying to get that officer.
Yes, Your Honor. The state is ready to go on I believe it's the Tripp matter.
Tripp? What?
The state is going to call Officer King to the Zoom call.
How you doing? Good afternoon.
Doing well, sir. How about yourself?
All righty. And this is on who? I'm sorry.
Your Honor, this is with Tripp, Shockey Tripp.
Okay. All righty. Deputy, if we can get Shockey Tripp, please.
Your Honor, Mr. Tripp. Amen.
All righty, hold on. All right, now calling the matter of State of Georgia versus Shockey Tripp, charge and warrant number 2024 WAZ 01438, simple battery. Attorney Tipton, your witness.
Yes, Your Honor. The state is going to call Officer King to the Zoom call. Officer King, please raise your right hand. Do you swear or affirm any testimony? Do you swear or affirm any testimony you give today should be the truth, the whole truth, nothing but the truth, so help you God?
Yes, sir.
Thank you. You may lower your hand. Okay. Could you please state your name for the court, sir?
Officer King.
Thank you, Officer King. Officer King, how are you currently employed?
Patrol officer with Forest Park Police Department.
As a patrol officer, are you post certified?
Yes, sir.
Does being post certified give you authorization to investigate and make arrests relating to said investigations?
Yes, sir.
Okay. And were you working on January 16th of 2024?
I was.
Okay. And were you called to the McDonald's located at 4926 Old Dixie Road in Forest Park?
Yes, sir.
Is that within the boundaries of Clayton County?
That is, sir.
Okay. Why were you called there, sir?
We were called for a disturbance between the gentleman and the on the Clayton County screen at the moment. The manager at the time mentioned that the gentleman was harassing individuals inside of the establishment and causing disturbance there. Upon arrival, she mentioned that she attempted to ask him to leave several times. She even tried to attempt to use her cell phone to call, after giving these directives. And the gentleman, she stated that pushed her hand or hit her hand and then pushed her down and then left the establishment.
I see. So I just want to make sure. I understand. So she said that that the defendant pushed her to the ground and then caused her to hit her head on the leg of a table.
That's correct, sir.
And did you make contact with the defendant, Mr. Tripp?
I did make contact in the nearby church parking lot, where some of my fellow officers were able to make contact with him as well. And that's where we was able to put him in handcuffs.
How were you able to identify him as the aggressor in this crime?
Once we established, I gained identification. He did give us a false name. We did retrieve some documentation, which was a driver's license from out of state. We did run that through the GCIC and verify who he was. And we went back into the establishment, which was the McDonald's there on Old Dixie Road, which is stated in the report. And the manager there did confirm the individual, along with several of the employees that were trying to assist her at the time.
So that was a positive so I just want to confirm that was a positive identification from the victim and several witnesses. Is that correct?
Yes, sir.
Okay. And you mentioned earlier, but I just want to make sure I understand. Do you see Mr. Shockey Tripp on the Zoom call today?
Yes, sir. I do see him with an orange jumpsuit in the frame saying Clayton County Jail.
All right. Thank you very much. And based on the witnesses that you spoke with, did they corroborate the victim's story?
Yes, sir. They were the ones trying to attempt to, get him out of the establishment. And they, rushed him out of the store. And that's where we made contact with him with the next establishment, which is like a church parking lot as well.
I see. Okay. Thank you, officer. Those are all my questions.
All right. Cross, please.
Hi, good afternoon, officer.
How you doing?
Doing well. So, in general proximity, the church parking lot was about how close to the McDonald's? Could you tell us?
Literally like the next parking lot over, sir.
So right next door?
Correct, sir.
Okay, gotcha. And you authored a police report in this case, right?
I beg your pardon?
Sorry. Closer. I said you authored a police report in this case. Is that right?
Yes, sir.
I believe I have it. It appears to me a pretty simple report about 2 or 3 sentences. Is that accurate?
Yes, sir.
The testimony you're providing, I'm sorry. Did you?
I was saying that was just based on information once I made contact and what I seen and observed for myself, sir.
I got you. I know you gave us a lot more detail in your testimony. Were you getting that from memory? Is there another narrative that you have? How were you recounting that to us?
That's just based off of what I remember from the incident upon arrival.
Okay, gotcha. I noticed in the narrative that there wasn't any discussion of any IDs or anything like that, no false reporting, anything of that nature. Is there any reason why that wasn't included?
No, sir. This is based off of when I made contact with them. When I made contact with Mr. Tripp, which was away from the establishment of the McDonald's, whereas my fellow officers that is stated in the report, they made contact with him first, and upon arrival, we took over from that point. Once I made contact, they passed on information as well, and we was able to go back to the McDonald's establishment where the incident did occur at the time.
I see. So you were getting that second or third hand. You did not have any interaction as far as a different name or any sort of alternative identification. Would that be fair to say?
Slightly, we did actually as well. Outside of my officers trying to confirm, we also made contact with Mr. Tripp and asked him as well. So that was the information given from Mr. Tripp verbatim.
I see. But you were able to identify Mr. Tripp.
Yes, sir. Once we was able to do a proper search, a pat down, and was able to retrieve his identification, we were able to make contact with what was on the identification and through the GCIC and CIC service.
I see. The manager in speaking with her, she's the alleged victim, Miss Wolford. Is that right?
Yes, sir.
And did she give you an identification of the defendant, or was it her coworkers that gave you the identification?
She was able to identify the gentleman because she was able to, we put an alert for the criminal trespass warning as well.
I see. And she confirmed that it was a push. Is that right?
Correct, sir. She did give a written statement as well. After explaining, she did verbatim write down exactly what happened with her written statement. And she did mention the gentleman did push her down, causing her to fall and hit her head on the stool in the establishment.
I see. But no injury, correct?
She stated she didn't have any injuries.
The statement that you're referring to, she filled out a written statement for you?
That's correct.
Did you collect that?
We did, I believe so.
Okay. No further questions, Your Honor.
All right, any redirect?
No redirect, Your Honor.
All right, closing arguments, Attorney Tiffany?
Yes, Your Honor. Your Honor, this is just a simple battery, and all we have to show is that there was an unwanted touching or an unlawful touching. Here we have the defendant who was seen pushing the victim to the ground. The officer testified that he spoke with the victim who corroborated that story, and that there were several other witnesses on scene who corroborated that story. They then identified the defendant after they apprehended the defendant. They determined that he was in fact the correct person based on an identification from the victim and from other persons on the scene. So based off of that, the state believes that we do have a simple battery.
All right, thank you. Attorney Moore?
Your Honor, will submit. Thank you.
All right, based upon the evidence presented, I do find that there is sufficient probable cause to bind this case over to Superior Court, Clayton County. That is the order of the court.
Thank you, Your Honor. May we release Officer King?
Yes, thank you, officer.
Thank you, guys. Have a great day.
All righty. Any other officer we have here ready to go?
Your Honor, I think Officer McFadden, we were able to get back in touch with him. Yes, Detective McFadden is back on, Your Honor.
Okay, and who was that for?
Detective McFadden was here for the Stevens matter.
Stevens.
Yes, ma'am, the loitering and prowling.
And Your Honor, I believe Jenna Jacobs asked about Corey Morgan filling in for Derek.
Oh, Ms. Thomas, I did send you, I hope you got a copy of the preliminary hearing waiver that I sent for Mr. Morgan.
Yeah.
Okay,
Yes,
good.
I did receive it.
Thank you.
You're welcome.
And so is that officer on that case? The officer on that case is not on, right?
I'm sorry, for which case, Your Honor? For Morgan?
For Morgan. I received a chat from Jenna Jacobs regarding that case.
Excuse me, that case was waived, so he's free to go if he hasn't already. Is that officer still on?
No, Your Honor.
I was about to say, I made that announcement an hour ago.
Yes, Your Honor.
Well, there was a Jenna Jacobs that's filling in for that officer that sent a chat asking that question.
Gotcha. Jenna Jacobs works with our office, Your Honor. I think that she's filling in for victim service officer,
Mr. Palmer?
Yes.
So, yeah, so,
right.
yeah, it was just waived, so I can let Ms. Jacobs know that if she needs to go over anything with me afterwards.
Yes, okay, thank you.
And thank you. I thought it was an officer.
All righty, and so we're going with Stevens, you said?
Yes, Your Honor.
Deputy, can you get Demario Stevens, please?
Man, we getting it.
I'm sorry? Are you getting him now? Okay.
Yes, ma'am, he coming up.
All righty. Now calling a matter of State of Georgia versus Demario Stevens, 2024 WA 01418, loitering and prowling. Attorney Assistant Solicitor Tipton, your witness.
Yes, Your Honor. Thank you. The state's going to call the Zoom call Detective McFadden. Detective McFadden, can you raise your right hand, please? Do you swear or affirm any testimony you give today shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you. Please state your name for the court.
Joshua McFadden.
Thank you, thank you, Detective McFadden. How are you currently employed?
I'm a lieutenant over at City Mart Police Department on day shift.
Oh, excuse me, Lieutenant McFadden.
No, you good.
I got you. Okay. Lieutenant McFadden, as a police officer, are you post certified?
Yes, sir.
Okay, being post certified, do you have the authority to investigate crimes and make arrests based off of those investigations?
Yes, sir.
Were you working on January 15th, 2024?
Yes, sir.
Did you have occasion to go to the U-Haul store at 1549 Mount Zion Road?
Yes, sir.
Is that inside the city limits of Morrow?
Yes, sir.
Is that within the limits of Clayton County?
I'm sorry. Hold on one moment. I did not call out warrant 2024 WA 01419, which is drug related items. My apologies. He has 2 charges.
Yes, Your Honor.
Okay, go ahead and proceed.
Yes, Your Honor. Thank you. That U-Haul location, is that within Clayton County's borders?
Yes, sir.
Thank you. Why were you called there that day, sir?
I was called there in reference to Mel's, I'm gonna use the term dumpster diving. So spoke to an employee. He just said he cleaned out a storage unit and the dumpster did have personal items in it. And he did not want those subjects walking away with those items out of the dumpster.
Okay, and when you arrived, how did you speak to, let's see, when you arrived and made contact with the employee, did you then make contact with the 2 offenders?
Yes, sir. I had to go looking for him. He gave me the direction, and at that time, I went in that direction looking in the wood line, and that's when I located a couple of bags. Then I found the 2 subjects laying down in between 2 trees with leaves and pine straw covering themselves up.
I see. Did they tend to be covering themselves up to camouflage themselves?
Yes, sir.
All right, then, let's see. And they both had ended, did they both have their eyes closed?
Yes, sir.
They were laying on their backs?
I can't recall if they were laying on their stomach or their backs. I believe they were laying on their backs. So yes, sir.
Okay. One moment, please. And did you search, did you make contact with these, with both these individuals? Did they
Yes.
speak, did you speak with these individuals? Excuse me.
Yes, sir.
Okay. What did you ask them if you could search them?
Yes, sir, I did.
Okay. What did you find when you searched them?
For Mr. Stevens, when we looked through his bag, we did find two glass pipes with methamphetamine residue inside of them.
Let's see. And on his co-defendant, did you search him as well?
Yes, sir. He in his chest pocket and his wallet, there was methamphetamine found.
So the glass pipe, you mentioned that you saw a glass pipe with methamphetamine residue. Is that a drug-related object?
Yes, sir. The way it was used in this case, it was.
Mhm. And how does one usually use a pipe like that? Do they smoke it? Is it a smoking pipe?
It would be a smoking pipe. It had burnt marks at the bottom. It had a crystal inside of it.
And what time of day was this?
This was going to be during the afternoon time around, I can't 100% say, it was around 2 or 3 in the afternoon.
I got you. Would it be, check one thing. I see you cited the defendant with loitering. What was your basis for citing them with loitering?
They had no place of business being there. He didn't have a storage unit on U-Haul property, and he wasn't renting a truck at U-Haul.
I see. He was not renting a truck at U-Haul.
And plus, he was hiding in the grass in the tree line. That's not a common place for people to be laying if they're trying to take a nap or, I guess, get out of the sun.
I see. And so based on your knowledge, training, and experience, did they appear to be loitering? Did they appear to be hiding from from yourself in order to continue breaking the law?
Yes, sir.
Okay. Okay, I have no further questions for you at this time. Thank you, sir.
All righty, Cross.
Thank you, Your Honor. Good afternoon, Lieutenant McFadden.
Hey, how you doing, man?
Doing well. Lieutenant, it is Lieutenant, right? Not detective?
Yes, sir.
Okay, thank you. Lieutenant, when you encounter these gentlemen, you asked if you could search them, correct?
Yes, sir.
Did you have any other conversations with them at that time?
I explained to him while I was there about the dumpster diving.
Mm-hmm. And was anything else discussed?
And I asked them if they had anything on them before I searched them.
Gotcha.
I give everybody the common courtesy to asking them before I do anything else. So,
gotcha. With regard to it was, did you say it was 2 pipes that were found?
Yes, sir.
And where were those found exactly?
Would it be in his bag?
that he pointed out to be his bag.
Gotcha. Where was the bag in relation to him when you came upon them?
If they were laying down, it was going to be to their left side,
Gotcha.
to the left of them.
About how far away was it from him, approximately?
Say a couple of feet, probably about 5 feet away from them.
Gotcha. When you found these pipes, you indicated that there was residue. Is that right?
Yes, sir.
This residue, did you take a sample of it in any way?
I didn't have any test kits at the time, but based on the appearance of it, and I did lay it out for my K9, the smell, and she alerted that it was some type of narcotics.
Did you, I think you just testified to this, just to be clear. I know you said you didn't have any field test kits, so you have not tested these pipes or the residue in any way. Is that accurate?
That is accurate.
And with regard to a K9, you authored a report in this case, correct?
Yes, sir.
I believe, did you reference that report prior to your testimony here today?
Yes, sir.
And did you include anywhere in that report anything to do with your K9?
I did not, sir.
Is there any particular reason why?
I just didn't put in a report because a sample was taken, but it was sent to GBI, and I did notate that in the report itself.
Did you utilize the K9 in any way to locate the defendants?
I did not.
The staff of the U-Haul, could you identify which staff it was that called you out?
It's going to be the general manager. I can't remember his name off the top of my head.
See, that's all right. The concern was that the defendant and the other gentleman were in the dumpster. Is that right?
Yes, sir.
And there was property that was intended to be taken away by a garbage truck in the dumpster. Is that accurate?
Yes, sir. He called this. He got dumpsters in the bag, but this one he brought in especially just so he can empty out a storage facility. So he brought that just in for the units.
An extra dumpster, I guess?
Yes, sir.
Gotcha. But that dumpster was intended for refuse from the facility. Is that accurate?
Ask that again. These what?
The dumpster that we're talking about is a dumpster that was intended to receive trash. Is that
Yes,
accurate?
sir.
Okay. Thank you, Lieutenant. No further questions.
All right, any redirect?
Yes, Your Honor. Lieutenant McFadden, I want to go back to the loitering issue. So, would it have been usual for someone to have been dumpster diving? Would it be usual for law-abiding citizens to be in that dumpster searching for property?
That's not normal.
Okay. Would it have been normal for law-abiding citizens to attempt to hide themselves under pine straw and leaves?
That's not normal.
Okay. Would it have caused immediate concern for the would dumpster diving, would that cause immediate concern for the property of the U-Haul location?
Objection, Your
Yes,
Honor.
sir.
Speculation, and it's also the ultimate question.
Your Honor, it's based, I can rephrase it to be
Please rephrase it.
Yes, of course. Based on your knowledge, training, and experience, would you say that the property that is within the trash bins, within the dumpster, was under any threat of being spirited away based on your knowledge, training, and experience?
Yes, sir.
Okay. And let's see. And I want to make sure I understand this too. The two males, did they take flight upon your arrival, or just prior to?
I think once they saw us pull in the parking lot, because we did go into the front doors, which was the wrong location. They were in the back. So once we found out everybody was in the back, that's when went to the back, and prior to that, they had left. Maybe a couple of 30 seconds before we got to speak to the employee.
And I just want to make sure I understand too, when I mentioned, we mentioned earlier that they tried to camouflage themselves. Camouflaging oneself, an endeavor to conceal oneself or one's identity.
Yes, sir.
Okay. And based on your knowledge, training, and experience, the pipe that you observed, did that appear to be a drug related? Did that appear to be a methamphetamine pipe?
Yes, sir.
All right, thank you. I have no further questions.
All right. Did you tell me again what business was this?
Are you asking me, Your Honor?
Yes.
It's going to be U-Haul.
He was actually on the property.
Yes, ma'am. Yeah. The well line is still U-Haul's property.
All right. Based upon the evidence presented, I do find it's found sufficient.
May we have an opportunity to discuss briefly?
Yes, go ahead. Certainly.
Thank you. I don't know, Mr. Tipton, I was going to let you go first.
Yeah, I'll go first. So, Your Honor, with regard to the loitering, OCGA 16-11-36 states that a person commits the offense of loitering or prowling when they are in a place or in a manner not usual for law-abiding individuals under the circumstances would be at, and they cause immediate concern to the safety of persons or property. Here we have somebody who's inside of a dumpster. That's not a place for law-abiding individuals. I suspect that the defense will make the argument that it's abandoned property once it goes into the dumpster. I would argue that it is not, that it is in the custody of U-Haul until a vehicle comes and collects it, at which point it becomes the custody of Waste Management. This would cause immediate alarm for safety, immediate alarm or concern for the safety of the persons or property, because one, that is technically still U-Haul's property, and two, people are going to that dumpster all the time. Folks could be going out there and feel like they were going to be jumped or robbed or anything at that dumpster. Further, Your Honor, it specifically says in 1611-36 subsection B, and I'm quoting here, among the circumstances which may be considered in determining whether alarm is warranted is the fact that the person takes flight, which we have, refuses to identify themselves, which we do not have, or manifestly endeavors to conceal themselves or any other objects. And I think that that's perhaps the most important factor here, Your Honor. We have someone who is quite honestly cartoonishly trying to hide under leaves and pine straw. That is clearly an element in determining whether or not there's loitering or prowling, and that's where so for that reason we've got a prowling. Further, Your Honor, the methamphetamine, the meth pipe, the officer did state that based on his knowledge, training, and experience, there appeared to be a glass pipe with meth residue on it, methamphetamine residue, excuse me. He submitted the methamphetamine residue, the methamphetamine packets on the co-defendant to GBI because he did not have the test kits present. However, his canine did detect it as positive. The officer does not necessarily need to state that his canine made a positive read on that because he's waiting on the GBI form. Further, Your Honor, the glass pipe itself, based on his knowledge, training, and experience, is used to ingest or otherwise introduce methamphetamine into the body. And based off of that, the state believes that there is probable cause for the methamphetamine. Based off of these facts, the state would request that the court find probable cause and bind it over to state court.
All right, Attorney Moore.
Thank you, Your Honor. Judge, we take two issues with the loitering and prowling discussion.
Okay.
First and foremost being that, quoting from the statute, law enforcement officer shall, prior to any arrest for an offense under this code section, afford the person an opportunity to dispel any alarm or immediate concern which would otherwise be warranted by requesting the person to identify himself and explain his presence and conduct. I asked the officer multiple times, I know the state did too, about conversations that he had with the defendant. I did not hear any sort of conversation along those lines as outlined in the statute. Thus, I would argue that law enforcement did not comply with the statute, and by virtue of the wording, he cannot be guilty of this charge. In addition to that, Your Honor, with regard to loitering or prowling, I know the statute focuses on safety of people and safety of property. I think it's kind of distressing to hear arguing about the safety of trash in the back, people worried about people getting hold of the trash. I think that's not exactly logical. This was refuse. The officer said it was garbage. It was a dumpster that contained garbage. And so while people could be, if there's a trespass issue, if they've been told not to be there, that's fine. That's a way of getting them off the property. But as far as being worried about your trash in your dumpster and somebody taking your trash, that's somewhat disingenuous to make that argument. And thus, I would argue that statute, there is not probable cause for loitering and prowling. With regard to the drug objects, the officer did not have any information about the residue supposedly on the pipe other than his dog, which we have no idea what kind of dog it was, whether or not it was trained. It wasn't even in his report, and it was not field tested. We have no idea what those pipes, if they had substance on them or not, simply that they were glass pipes in his possession. And for these reasons, Your Honor, we'd argue there's not probable cause for either charge in this case. Thanks.
All righty. So based upon the evidence presented, I do find that there is sufficient probable cause to bind case over to state court of Clayton County. That's the order of the court.
Thank you, Your Honor. May Lieutenant McFadden be excused?
Yes, thank you.
Thank you. Have a good day, Lieutenant.
And so I know that we were requesting, who are we going to do next?
So, Your Honor, I wanted to confirm the last case I have the states ready for is Willingham. Washington was the case that the state had requested a continuance on. Yeah, based on the officer being in service training just for today.
So I see I have a Bobby Willingham. Did we do something with that one?
Bobby Willingham is the last one that we have to do after, is the only remaining one that the state is ready for, Your Honor.
All right. And so, counsel, Attorney Moore, what is your response to the state's request for a continuance?
And this is on Washington, just so I'm clear. Washington, the state's requesting a continuance, but we're ready on Willingham. Is that accurate?
That is correct, sir.
Okay.
Yeah, but we're talking about Mr. Denise Washington or Mrs. Denise Washington right now. What is your position on the continuance?
Gotcha. Thank you, Your Honor. With regard to Ms. Washington, I would state, Judge, that she's been in custody on this case. As I was stating earlier, I believe we discussed it briefly, since January 17th. Today would be February 20th, and still has not had a determination on probable cause. The charges here, I know we would get into the meat during a preliminary hearing. However, I think there may be some indications of mental health issues going on with her as well. I think in all fairness, to make her wait another week, 2 weeks, for an officer, especially when we're not entirely sure the reason why the officer is not here would be simply unfair to my client. The state can still file an accusation. They can still bring it into state court at a later date. But given the length of time that she's been in custody, we would request this be dismissed and her be released.
And counsel, Attorney Tipton, what was the reason that he's not here?
Your Honor, Officer Jeremy Parks is currently out at training that's mandatory. He could not make it today. Further, Your Honor, I do want to bring it to the court's attention that this is the first preliminary hearing that Ms. Washington has been placed on. It's a situation where the state has not asked for a continuance prior to, and the only reason that we are requesting this is because of mandatory training the officer is currently in. We will have the officer for the next date, and we do not see requesting a further continuance after today.
Okay. All righty. So I will continue this matter till you know when the training is over?
It's a one-day training, Your Honor.
So I'm going to do it till next week.
Yes, Your Honor.
Your Honor, if the court's intention is to go ahead and set that new date, if I could, as soon as we finish with Mr. Willingham, if I could just have a brief conversation. The prime evil that we experience in these preliminary hearings is when, the amount of time everybody has to wait to get to their hearings on misdemeanors.
Right.
She may just want to waive it, even though we've waited this long, just to avoid that additional week of time, going up to. So if I could just briefly speak with her to see if she wants to do that prior to just resetting it.
Okay, and I did look at her criminal history for the purpose of trying to determine if she would be eligible for a judicial release. Unfortunately, she doesn't qualify. She has a lot of probation violations. Otherwise, if she didn't have this extensive history, I would have entertained unsecured judicial release, but she has an extensive criminal history.
I understand, Your Honor, and I appreciate very much you doing that for us to have a look at that.
And to let you know, I would put her on the calendar for next Tuesday.
Yes, ma'am.
And so, but you want to go in the breakout room with the jail, or you want to wait till we're done with this hearing?
Whatever you would prefer, Your Honor. And actually, I guess, he's the last officer here, just to be courteous. Let's go ahead and with this, and then he can leave if the court would allow. Then I can go in the breakout room to prevent extra people from having to wait around for me.
Okay, so who do we have here in front of me? What inmate is that?
Is that Mr. Willingham, Your Honor?
Okay, Mr. Willingham. All right, so let's go with Mr. Willingham, and then we'll do the other things thereafter. All right, so State of Georgia versus Bobby Willingham, 2024 CW 50202, battery family violence. Your witness, Attorney Tipton.
Yes, Your Honor. The state is going to call Officer Doss with the Forest Park Police Department. Officer Doss, please raise your right hand. Thank you, sir.
Excuse me. It's going to be Officer Doss and Officer Peterson on this case.
Oh, it's going to be Officer Doss and Officer Peterson.
Yes, because at the time of the arrest, Officer Peterson is actually my trainee. He did not have the part where he can take out the warrants. So I did take out the warrants, but we were both out there at the same time. So we were both out there.
No problem. Before we proceed, Mr. Moore, are you going to request that they be sequestered, or are you going, or are you going to waive that?
I'll just waive that.
Okay, thank you. Okay, Officer Doss, please, do you swear or affirm any testimony you give today shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, thank you. Please state your name for the court.
Officer Doss, Officer S.A. Doss with the Forest Park Police Department.
Thank you, Officer Doss. Officer Doss, were you working on, so you mentioned the Forest Park Police Department. Are you currently employed there?
Yes.
Okay. Were you employed there on January 16th, 2024?
Yes.
Okay, are you post certified?
Yes.
Being post certified, does that give you the ability to investigate crimes and make arrests based on your investigation?
Yes.
Okay. Were you dispatched on January 16th of 2024 to 794 Dennis Street in Forest Park, Georgia?
Yes.
Is that here in Clayton County?
Yes.
Okay. Can you tell me why you were dispatched there?
Yes. So Officer Peterson and I was dispatched to 794 Dennis Drive in reference to a disturbance. We were out there actually prior to the second call. We were out there about 30 to 45 minutes ago before this second call came out in reference to a disturbance. The first one was about Mr. Willingham being aggressive towards the victim, and she wanted him to leave. We explained to the victim that she would have to go through the Clayton County courts to do a legal eviction through the courts to get him evicted out the residence, and that she cannot just kick him out. That was the first call. The second call came out that the victim stated that Mr. Willingham was being aggressive, and he made threats about he was going to signal 48 her, which is basically making threats to kill her. So we were right on scene. We spoke with Mr. Willingham. Mr. Willingham stated that he was heading to the kitchen and to make a sandwich. And Miss Watkins, which is the victim, she became verbally abusive towards him. He sustained a minor laceration to his hand of when he stated that Miss Mary had struck him with the hammer on his arm. He had sustained a laceration to his left palm. We spoke with the victim, who stated, Ms. Watkins, who stated that Mr. Willingham became upset because she called the police earlier on him earlier in the day before the second call, and that Bobby jumped in her face, making multiple threats of killing on her tonight. And she stated that Mr. Willingham grabbed her by the head and pushed her into a kitchen table that caused her to fall back. As soon as she was falling back, she grabbed a hold of a hammer that was nearby, and she struck it on his arm to have him let go of her. We did speak with a third party. We did speak with a third person in the house, who did state that he heard a verbal dispute between Miss Mary and Bobby, and when he came out, he seen Bobby grabbing Mary's head and pushing her into the table and making her fall. When she went to fall back, she grabbed the hammer, and out of self-defense, she struck him to have him basically let go of her. We did take him into custody at that time for the simple battery of found violence. And when we arrived at the jail, he was first cleared by our EMS on scene. Once we took him to the jail, the charge nurse at the jail did refuse him due to his injuries on his arm in reference to the hammer strike. We took him to the hospital, and then we obtained an arrest warrant. I obtained the arrest warrant due to Officer Peterson did not have credentials at the time to take out the warrants.
I see. Okay, thank you, Officer Dost. So I want to go back and just make sure that I understand exactly what happened. So were you able to determine that they were both residing at 794 Dennis Drive?
Yes, they were. Actually, she stated that he's been actually residing there for a while, because she let him reside there due to his circumstance being home, for him being homeless.
Okay. And did he state that he lived there as well?
Yes.
Okay. Based on your contact with the third party witness, which I want to make sure, is that third party witness Charles Collins?
Yes.
Okay, based on your contact with Mr. Collins, did you determine that Miss Watkins was acting in self-defense?
Yes.
And did you determine that Mr. Willingham was the primary aggressor?
Yes.
Okay. And did you see any injuries on Miss Willingham's person?
Mr. Willingham at the time he had that little it's like a little laceration to his left hand on
Okay.
the strike.
Gotcha. And how about Miss Watkins?
We did not I did not see any visible injuries at the time. Officer Peterson may have because I stepped away real quick in the other room.
Okay. I don't know if I asked this earlier. Is 794 Dennis Drive, is that inside of Clayton County?
Yes, it's in the city of Forest Park in the county of Clayton County. In the jurisdiction of Clayton County.
I see. And do you see Mr. Willingham on this Zoom call today?
Yes, he has a white t-shirt, orange jumpsuit with the glasses on him, and he has a beard. It's a male.
Thank you. Those are all the questions I have for you at this point, Officer Doss. Thank you. All right. And so,
No questions, Your Honor. Thank you.
All righty, closing argument.
Your Honor, I actually wanted to call Officer Peterson as well. He was the other officer present.
Okay.
If I may, Officer Peterson, could you turn on your camera? Okay, I see you. Officer Peterson, please raise your right hand. Do you swear or affirm any testimony you give today shall be the truth, the whole truth, nothing but the truth, so help you God?
Yes.
Thank you, Officer Peterson. Please lower your hand. Please state your name for the court.
Officer Joshua Peterson.
Thank you, Officer Joshua Peter. Thank you, Officer Peterson. Can I get how are you currently employed?
Forest Park Police Department.
I got you. And are you post certified?
Yes.
I got you. Being post certified, are you certified to investigate crimes and make arrests based on those investigations?
Yes.
Okay. Were you working on January 16th of 2024?
Yes.
Did you have occasion to go to 794 Dennis Drive?
Yes.
Okay. Why were you called to 794 Dennis Drive, sir?
We were called to 794 Dennis Drive in reference to a disturbance among two people living at that location, Mr. Bobby Willingham and Miss Watkins. We were called there originally because them two were getting into a verbal dispute, and she wanted him removed from the premises. Based off him living there for about 2 years, which was stated, we explained to her that if you wanted him evicted from the property, that you would have to go through Clayton County courts. She was very upset about it. She stated she did not have any funds to do so, but that the next business day she would go down there to try and get Mr. Willingham evicted. I advised, along with my MPO, Sadas, we advised that for the remainder of the night that they would stay into separate, their own separate areas of the home, and if we were needed to come back out. We did get another phone call, dispatched back out to the same property that was 794 Dennis Drive, Forest Park, Georgia, in Clayton County, off of stating that Mr. Willingham was being irate. He was threatening to kill Ms. Watkins, and that it had lingered all the way outside. The disturbance lingered outside. When we arrived on scene, Ms. Watkins was leaning against her car. She said that she was scared for her life. When we entered into the home, she entered behind me and Sadas, and when we spoke with Mr. Bobby, originally, Mr. Bobby Willingham, that is, originally he actually denied, having contact with her, being in any type of dispute with her. When she proceeded to tell what happened, that's when he interrupted her, stating that he was heading to the kitchen to make a sandwich and she was being verbally abusive towards him. Later in the investigation, we found that that was not true. What she stated was that he was upset that she called the police on him earlier, and he barged at her, being very irate, and they begin to argue. As they begin to argue, he took both of his hands, placed them on the side of her head, pushing her into the kitchen table, where she grabbed the nearest object, which was a hammer, striking him on his lower left, between palm and wrist area, to get him off of her in self-defense. There was a gentleman there named Mr. Charles Collins. He was very fair. He was not comfortable at first stating what occurred, but he did state, he pulled me in the kitchen along with Officer Dodds, Corporal Dodds, who came in right after, stating that he witnessed Mr. Bobby Wilmingham place both of his hands on Miss Mary Watkins, pushing her into the table. He witnessed him yelling and cussing at her. And he stated that he even tried to intervene and break up this altercation. However, Mr. Wilmingham was so irate that he wound up pushing both of them. And that was the reason why Miss Mary Watkins struck him with the hammer.
I see. Based off of that, I see that you and Officer Doss took out warrants for simple battery family violence. Is that correct?
That is correct. Reason being is we, Forest Park Rescue Team, they come on and examine him, and they stated that it was very minor injuries. I think he had a small cut. And so it was just a wipe. They performed whatever they did medical on him, and they wrapped him up and stated he was fine. We did arrest him for him being a prominent aggressor. When we arrived to the Clayton County Jail, they refused to take him in, because they felt as though that he needed to be transported to the hospital for further to be seen further by the doctors.
Your Honor, I just noticed something that I do want to bring to the court's attention. It appears that there's a clerical error on the calendar. It's listed as a battery family violence, but on the warrant, it's listed as a simple battery family violence. So I just want the court to take note in case that affects how Mr. Moore would like to do questioning. Because I just noticed that on the warrant, and then looked it up in CPU 8 and saw that there seems to have been a clerical error on their part.
And so it should be a simple battery instead. Which one should it be, are you saying?
It should be a simple battery, Your Honor. I believe Your Honor has a copy of the warrant. And if you look, it says misdemeanor, simple battery family violence, 16-5-23F, 1 count.
Okay, yeah, that's not correct. It should be simple battery.
Thank you for pointing that out. I was operating strictly by the calendar, so I was thinking that we were dealing with the battery family violence.
I just realized that I just was looking at that calendar, and then I looked at the warrant. Your Honor, if this changes Mr. Moore's decision not to cross Corporal Doss, the state would consent to him being allowed to cross after we wrap up Mr. Peterson.
Thank you very much, Mr. Tipton. I appreciate it. Based upon the change in understanding of the circumstances, I don't feel it's necessary to open up cross-examination of Officer Doss again, although I appreciate the offer. Although at the appropriate time, whenever, I would like to have a few questions for Officer Peterson.
Okay, all righty. Go ahead and proceed. Thank you.
All right, thank you. Sorry to break that up, Officer Peterson. Just a little error on the clerk's office's end. Okay, then. So I just want to make sure I understand. So there was a neutral witness that said that he observed Mr. Willingham as the primary aggressor. Is that correct?
That's correct.
Okay, based on your training and where Mr. Willingham was hit, did that appear to be excuse me, let me withdraw that question. Where exactly was Mr. Willingham hit?
It was hit on the left arm. So he had a marking on his palm, but it was actually some type of bruise on his lower left arm.
Yes. And did you observe any injuries on Miss Watkins?
Miss Watkins did state that her neck, that based off him pulling her hair and her falling, that her neck was hurting. She did show me her neck. I examining it, I could not really see any particular bruises. However, there was red marking, but I couldn't tell if that was the color of her, just coloration of her skin, or if that was from that incident that occurred.
Okay. And you did confirm they lived together. Is that correct?
Correct.
Thank you. I have no further questions for you, Officer Peterson. Thank you.
All righty, Cross.
Thank you, Your Honor. Officer Peterson, you did you say that the defendant was checked upon entering the jail and they didn't want to accept him? Was that you that testified to that?
Correct. Yes, sir.
And that's because they wanted him to go get checked out at the hospital. Is that right?
Yes, sir.
And that's because injuries to his arm. Is that fair?
Yes, sir.
And those injuries to his arm were sustained, were caused by a hammer. Is that right?
They were unsure of that. They were unsure of that actually, and the reason actually Forest Park Rescue was unsure of that as well, based off what occurred, and they stated that it looked like an old marking, so they were unsure. When the nurses that was at Clayton County Jail, when they examined him, they actually stated that they were unsure as well if it was from that incident or not. So they wanted to be on the safe side, so they wanted to checked out by further.
I see, but they were concerned about the injury. Is that right?
They were concerned about a swelling on his arm, but what he stated was what Mr. Willingham stated that he was, I guess, hurt from that altercation was what happened around his left palm wrist area. But there was a swelling on his arm, so they wasn't sure if that was fluid, if he had hit his arm. They wasn't sure where that came from.
Are all parties fairly confident that the alleged victim in this case used the hammer? And to some degree, I'm not saying whether he's greatly injured, slightly injured, whatever, that the hammer was used in some degree to remove him from her? Is that the conclusion that you drew?
Yes, sir.
And so the swelling involved very well could have been due to the hammer. Is that right?
Yes, sir.
And so this third-party witness was Mr. Collins, right?
Yes, sir.
Mr. Collins stated that he came in the midst of the altercation. Is that fair to say?
He stated that he was there from the beginning. He did not get involved in the midst of the altercation until it got physical. But he was standing in the frame of his bedroom when he said he had heard and he was watching them pretty much arguing, and Mr. Willingham stating that was embarrassed, that the police was called on him and that she shouldn't have did that. And then he stated that Mr. Willingham made all type of threats to kill her.
No further questions, Your Honor. Thank you.
All right, any redirect?
No redirect, Your Honor.
All right, closing arguments, Attorney Tipton.
Yes, Your Honor. Your Honor, this is a simple battery family violence. all that's required to be shown at this point is that there was an unwanted or offensive touching of between two parties where the parties live together. Here we have a situation where the defendant, Mr. Willingham, is accused to have grabbed the victim, Miss Watkins, by the hair and essentially slamming her around and grabbing her and throwing her around the premises of the incident location. I suspect that the defense is going to argue that the injuries to the defendant were such that the defendant could not have been the primary aggressor. However, Your Honor, if you just look at the facts of the case, if you look just at the defendant himself, the defendant is 6'4" and weighs nearly 200 pounds. He's a pretty imposing guy. He could easily throw many people around by grabbing them by the hair. Him being the primary aggressor at that point did give the victim, Miss Mary Watkins, the authority to use reasonable force to protect herself. So she had to grab a nearby instrument, which was a hammer, to protect herself. And then they both stated that they resided together. Therefore, we have the simple battery family violence portion that they reside together, and the initial grabbing of the hair and throwing around the incident location, that would be the unwanted or unwelcome touching. For that reason, Your Honor, the state believes that this case should be heard in state court, and we specifically would request that the court find probable cause.
All righty, go ahead, Attorney Moore.
Thank you, Your Honor. With regard to the arguments that I might make, actually, I would agree with the state that those are trial arguments. And thus, I won't be barking up that tree here today, other than to say that the size of my client may or may not be an issue for self-defense. But no further argument, Your Honor.
All right, so based upon the evidence presented, I do find that there is sufficient probable cause to bind this case over to the state court of Clayton County. That's the order of the court.
Thank you, Your Honor.
All righty, does that conclude the calendar?
I believe it does, Your Honor.
I think it does. Your Honor, I was just going to ask if I could have a brief second with Ms. Washington prior to signing off.
Ended up collapsing mostly.
Okay, you are in.
Here until.
Okay, I will. I'm putting the jail. I'm assigning the jail to 1, and so you guys can rejoin. You're already in there, Attorney Moore.
Thanks, Judge. And it shouldn't be very long. I should just be able to ask her that and be right back. So
okay, but other than that, we should be good, right?
As far as I know.
Yes, Your Honor, I did want to know, as far as Mr. Jose Gonzalez, as far as his, I think I just now got the answer to that. That looks like Mr. Tipton's office is going to be handling that, getting his order over to you at the bond for his release.
Yes, I will await that.
All right, I will draft that. I will draft that order, and Your Honor will have that within the hour.
Okay. All right. So once the jail comes back, I guess the calendar is closed.
Yes, Your Honor. Thank you.
Okay.
Thank you, Judge.
Thank you. For those that don't need to stick around, you're free to go. Okay, who is Joshua Peterson trying to come in? Does anybody know who that person is?
Your Honor, that was the officer who was just on.
Oh, well, he's trying to come back for some reason. Let's see.
I think he probably thought that he needs to get back. I think is under the impression that he needs to come back to hear the verdict. Hey, Officer Peterson, we
Hey,
when they
I'm
found-
sorry, my phone died.
It's okay. Hey, they found probable cause. Thank you so much for coming in.
Okay, all right.
Have a good day.
Have a good one. You too. Thank you. Bye-bye.
Hey, sorry about that, everybody. I'm back. I did have a chance to speak with everyone. In your honor, I think for Miss Washington, we're just gonna leave it on the calendar, if that's okay. I've got contact info for family, to kind of try to get her situated. I did have a question, though. It was one of Mr. Lane's cases, Ms. Hines, that I believe was set for March 6th. She was asking me, and I told her I would at least ask about it, which we understand. I told her all that it was going to the 6th. She said that there was an additional warrant on a different date that I think was maybe supposed to go to Superior Court, but I'm not sure if it was. And I can tell you the warrant number for her.
This is on Hines?
Yes, ma'am. I didn't know if that one needed to go over there. The reason I'm bringing it up is because I didn't know if that needed to go over on the same date or not.
Okay, so you're saying the warrant 1460 for simple battery, you're saying she's saying that that's right?
What I'm saying, I don't think anything is, the one that we're here for today, that's not a problem. That's not an issue.
Oh, okay, all right.
She understands. I told her about it. I told her what day we were doing and everything. It's over to the 6th.
Okay. Oh, so is she saying that there's additional charges somewhere?
There's another warrant that she was confused about that I saw that looked like there was a hearing on February 5th, but then it was for a simple battery.
It was in the jail as well?
I don't have any of the facts. I just know the public defender was assigned.
Okay, so we will pull that. If you would put your contact number in the chat, let me do a little research on that.
Sure.
And if that one too needs to go over to Superior Court.
I appreciate it. And it may be she was just confused and I didn't know what to tell her at the time.
Okay.
Put that in the chat right now. Thank you for.
And do you have that? Do you have that warrant number?
Yes, ma'am. I'm gonna put it in there in the chat too. It's
okay. Go ahead and give me that case number.
It is 2023 W 18423.
1842, and that's also a simple battery?
It's listed as a simple battery, but it was on the February 5th prelim calendar, which is a Monday.
Okay. Oh, a Monday, which that means it was felony. All right, so I will pull that warrant and take a look at that. And what were we doing on Denise Washington?
You had proposed, Your Honor, to just reset it to next week's calendar, and I just wanted to check with her first. And after our discussion, she indicated she just wants to leave it on there for now, on next week.
For next Tuesday, which is the 27th.
Yes, ma'am, if that's okay by you.
Okay. And okay, all righty. All right, we will continue that to the 27th. All righty, anything further?
I don't think so, Judge. Thank you very much for the extra time to help.
No worries. Have a great day.
Thanks, you too. Appreciate it.
All right, thank you, Your Honor.
Yes, thanks, Deputy. Thanks, Deputy. Great job today.
Yes, ma'am. Thank you, ma'am.
All righty. Okay. Go ahead.
Your Honor, I'm looking at the case now.
$7293 Winter Valley Court, Riverdale, Georgia 30274.
Your Honor, you're not on mute or you're not closed out.
Hold on. Sorry.
And you're still recording, Your Honor.